ambassador had almost completed the evidence on his written statement. In fact, he had 3 paragraphs to go. And the remaining part of his evidence would have dealt with his response to affidavits that had been supplied during that week by officials of the African National Congress. There's not much controversial in that response. And in fact, largely the contents of the affidavit and the ambassador's response will be common cause, save for perhaps a few observations that the witness might want to make. So it's been determined by your leave, Chair, to produce the remainder of the ambassador's evidence on affidavit. And then after that, he may return for cross-examination from various implicated parties, and suitable arrangements can be made in that respect. The second point is that he will also provide, sooner rather than later, hopefully, a supplementary affidavit which will deal with various corrections and clarifications that are required that emerged during his testimony. In addition, it may be that there are certain documents which are declassified in the interim that may also be put up as part of his supplementary affidavit. So in short, Chair, the affidavit of the ambassador will be concluded by way of affidavit. He will reappear, if you so rule, for cross-examination in due course.
Okay, no, thank you very much. I just wanted to make sure we've got the way forward with regard to his evidence on record, as well as exactly what happened, so that whoever reads the transcript understands what happened and what plan was put in place. But that's in order. Thank you.
Thank you, Chair.
Thank you.
Good morning, Chair.
Good morning, Ms. Hofmeyr.
Chair, I have discussed with members assembled in the room today if they have a difficulty with me removing my mask. They've indicated that they're sufficiently comfortable about the distance between us. My challenge is that my glasses mist up the whole time while I have the mask on. So with your leave, I request that I remove it when I'm questioning Mr. Mothibe and when I remain at the podium.
No, you may take it off. As I understand it, when we speak, we may take it off.
Thank you.
That's in order.
Thank you, Chair.
Thank you. And to the extent that the witness also might not be clearly audible when he speaks, he can take it off as well. Yeah, okay.
Thank you, Chair. Chair, I propose this morning, before we commence to swear in the witness, just to orientate ourselves as to where we are.
Yes.
In the aviation evidence in particular, because we've had quite a number of months break.
Yes, no, I do need to be reminded where everything fits in.
Certainly.
Yes.
So if I may proceed to that.
Yes.
Chair, in February this year, we had a session of aviation and related evidence. And it was towards the end of that session that we began looking at the role of auditors in the SAA group of companies. And you'll recall that we heard evidence from Mr. Polani Sokombela, who was a business executive in the Office of the Auditor General, and he was the person who'd led the audit at SAA and its group of companies for the 2017 financial year. Chair, you'll recall that before the Auditor General took over SAA's audit in 2017, the group had been audited by joint auditors comprising PwC and Nkonki Incorporated for the previous 5 years. In February, we'd intended to move straight from Mr. Sokombela's evidence to the evidence that we're in fact going to receive today from Mr. Motibe. Mr. Motibe was the audit partner from PwC assigned to the SAA audits for the years 2014 to 2016, but we unfortunately ran out of time during the February evidence session, and so we've returned today to present Mr. Motibe's evidence. Chair, in the public sector, auditors have a particular role to play. In addition to the usual responsibilities that they have when they audit private companies, they are required when they audit public SOEs to assess, amongst other things, the levels of that state-owned enterprise's compliance with legislation, including, and importantly for our purposes, the Public Finance Management Act, which we colloquially call the PFMA, and which really sets the test for regular procurement in a state-owned enterprise context. Chair, we propose to explore in Mr. Motibe's evidence a number of factors related to auditors in the public sector. And the question will be whether they properly discharge those obligations which are additional to the ones that they bear when they audit private companies. Chair, we submit that this inquiry is relevant to the Commission's mandate because one of the questions that you've emphasized repeatedly over the years now that this Commission has sat is the how question. If this Commission concludes that state capture, corruption or fraud did take place in the public sector, then it is supremely important for this country and for its future for us to understand how it occurred and indeed why it went unchecked. Chair, auditors are a watchdog institution. I gave you the reference last time to the case law that establishes that. And given their role and function, it's therefore fair to ask, if all this corruption and looting was potentially taking place in our public institutions in the past, how was it that auditors did not pick it up? In the context of SAA, that question becomes particularly pressing because after PwC and Nkonki had completed their 5 years of auditing for the group, the Auditor General stepped in to audit SAA for the 2017 financial year and found its finances in a state that can only be described as shambolic. So today we are going to focus on the following, with your leave, Chair, with Mr. Motibe. The first aspect we'll probe is the fact that, except for the first year of PwC and Nkonki's appointment, all 4 subsequent years they were appointed without any procurement process being followed. And this was against the advice of the Bid Adjudication Committee of SAA at the time and a legal opinion that was later procured. Their own appointment therefore constituted irregular expenditure for 4 solid years, and yet it was never disclosed as such in the financial statements. We'll then explore why it was that PwC and Nkonki both had joint business relationships and made payments to an auditing firm called Kwinana and Associates during their audit work for SAA. Now, Kwinana and Associates was the auditing firm of Ms. Yake Kwinana, who was both a non-executive member of the board of SAA for the period that these 2 firms were auditing the doing audit work at SAA, but she was also the chair of the Audit and Risk Committee at SAA, the very committee which year on year would approve the audit fees to be paid to auditors. We will then, in the third place, explore why not one of the significant transactions that have been dealt with extensively in the evidence before this Commission, and which there are indicators may have been the subject matter of fraud and corruption, and possibly state capture within SAA, and were products of the decisions of the board of SAA and in one occasion SAA Technical, was not identified by these auditors as reportable irregularities. And we'll spend some time just traversing with Mr. Motibe what reportable irregularities are. We had a bit of evidence on that from Mr. Sokombela, but not much. So I plan to pursue that with Mr. Motibe today. That obligation on auditors to report reportable irregularities is an important one, a serious one, and their failure to do so is in fact a crime under the relevant legislation. We submit that in the end, the Commission will need to determine whether any state capture, corruption or fraud that it finds to have taken place in the public sector was in any way facilitated by the auditors of state-owned enterprises. If it was, then the next question will be whether that facilitation was due to mere negligence, auditors simply not doing their jobs as they were supposed to, or something more sinister than that. Chair, we submit that even if it is only the former, even if state capture, corruption and fraud was not picked up by auditors of state-owned enterprises because of nothing more than their mere negligence, it is still important to expose that, because public funds were used to pay them for inadequate and substandard work, and the public deserves better than that from a watchdog institution. It may be, Chair, once these matters have been traversed not only in SAA but other SOEs, you may consider recommendations like the Auditor General should be better capacitated and should be running all the audits at state-owned enterprises with the level of dedication and commitment that we saw from Mr. Sokumbela and his team as he dealt with in evidence before this Commission over 2 days. Or it might be that you make recommendations that the annual review that the Auditor General is required to do under the legislation at the moment to approve external firms coming into SOEs should be stricter. There should be additional criteria. Those are the sorts of recommendations it may well be that this Commission wants to consider in due course. And so, Chair, it's with that background in place and just a reorientation of where we are, that without further ado, I have 2 procedural matters just to mention, and then I would beg your leave to swear in the witness.
Thank you. Please administer the oath of affirmation. All persons who are in the room must take responsibility to make sure that there is proper social distancing between themselves and the next person. I don't think that if you are sitting in the one row and there's somebody sitting immediately behind you in the next row, that's 1.5 meters or 2 meters. So do consider, there may be constraints that I don't know, but I just want to make sure everybody remembers that we must still try and, it may be that for TV or whatever, there are other constraints. I leave it to you to think about that, but there's enough room to make sure that there is proper social distancing. Okay, all right. Thank you.
Thank you, Chair. Please state your full names for the record.
Ule Joseph Motibe.
Do you have any objection to taking the prescribed oath?
No objections.
Do you consider the oath to be binding on your conscience?
Yes, I do.
Do you swear that the evidence you'll give will be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you. You may be seated.
Thank you, Chair. Just a few procedural matters before I begin with the questioning. Mr. Motibe is represented by a legal team. They did previously introduce themselves to you on the last occasion, but I wonder if I could seek your leave for them simply to place themselves on record.
Yes,
Chair, it might be convenient for Mr. Chappell to do so as he's seated at the moment, so we
That's
don't
fine.
have to move the
Yes,
podium and
that's fine.
sanitize it.
Let's do that. Good morning. Good morning. You can just put on, yeah, yes.
My name is Tony Chappell from the law firm Norton Rose Fulbright, and I have with me 2 of my colleagues, Ms. Ndluli and Ms. Thompson.
Thank you. Thank you.
Thank you, Chair. Then on 2 final procedural matters, insofar as Rule 3.3 notices for Mr. Motibe's evidence is concerned, that was done way back in February. There was one notice sent to Ms. Yake Kwinana. We received simply a 2 or 3 paragraph email in response from her. Chair, you've previously indicated in these proceedings that you require a proper and formal response to any affidavit that is sent to implicated persons. Ms. Kwinana does not purport in that email response to seek leave to cross-examine or any such thing. She simply puts up a few points in that email. I don't propose to deal with that with Mr. Mothibe today. It's in any event the intention of the Commission, and we have engaged Ms. Kwinana about this, to have her come and give evidence in due course, and so any matters arising there will be dealt with in that evidence.
No, that's fine.
And then the final procedural matter, Chair, is I understand that the Commission has received an affidavit from Mr. Simon Mantell, whose company Mantelli's Biscuits was awarded an SAA tender in 2014, which shortly after the award was summarily withdrawn. I had intended to question Mr. Mothibe on possible relevant matters arising from Mr. Mantell's affidavit, but I've been informed that his affidavit is forming part of a different process within the Commission. I have not considered it as a result, and I will not be traversing matters with Mr. Mothibe today in relation to Mr. Mantell's affidavit.
I wonder what process it is part of, because the last I knew was that one of the things you were considering is seeing whether the information that Mr. Mantell gives in his affidavit could be used to question Mr. Mothibe.
Indeed.
So I'm not aware what that process is, and nobody has talked to me about that process. So I'm concerned about that.
Chair,
Because you had considered it as a possibility.
I had indeed.
Maybe during the tea break, you could talk to me.
Certainly, Chair.
I'm concerned about that.
Indeed.
Because also, I think, correspondence that may have gone to Mr. Mantell may have alerted him that this was a possibility.
Yes.
And he might not have been told anything.
Yes.
And he might be concerned to say, this, I was told, was a possibility, but now it's not happening, and nobody has bothered to tell me what's going on.
Chair, can I say in response, I share your concerns. I do. It had always been my intention, but late last week I was given this information. But let me, if I may, over the tea break, raise it further with you. Thank you.
Okay, thank you.
Chair, then to move to Mr. Mothibe, finally. Apologies for the delay, Mr. Mothibe. Mr. Mothibe's evidence, Chair, is Exhibit DD19, and I request that we enter it into the record as such. It comprises initially a first statement and a series of annexures and then additional documents, but since the evidence in February of Mr. Sokombela, Mr. Mothibe then supplied a few weeks ago a supplementary statement, and so we've also just inserted that in the appropriate place in the bundle that had previously been prepared, and it spans more than a single file, so I beg your leave to enter it as Exhibit 19A and B.
There is the Liver Arch file marked DD, Exhibit DD 19A, and then there is one marked Exhibit DD 19B.
Correct.
I guess that the first statement is the one in A.
Correct, Chair.
And then the supplementary would be whereabouts?
It's
Would
just
it be-
after it. It commences at page 30.1 because we slotted it in so that it could, his two statements together would appear at the commencement of the file. So you'll see his first statement runs from page 1 of DD 19A to page 30 with its annexures. And then
I'm sorry. Did you say 15 something or 50?
no, apologies, Chair, 30.
53.
No, 30.
30.
So
Okay.
30, and then the second statement commences at 30.1, 30.1.
Okay, I found it.
Excellent.
And what is in 19B?
It's the further
Continuation of
additional
annexures.
documents.
Yeah. Okay, all right. In the meantime, since the last time, I'm not sure, we have been emphasizing that the file is not the exhibit, but the statement is the exhibit. And for convenience, what has been done in regard to, in some of the matters, is to call the file bundle something.
Right.
But the statements is exhibit whatever, and it's annexures.
Okay.
So we'll, when we talk about the exhibit, it will be a reference to the affidavit and its annexures.
Yes.
And, yeah, okay. The affidavit of Mr. Pule Joseph Matibe, dated or deposed to, or is it in the form of a statement?
It's in the form of a statement. It
Yeah.
was a request that it be provided as a statement so it could be confirmed under oath today.
Yeah,
But
okay,
you'll
no,
see
that's
it's
fine.
signed on page 14 on the
Yes.
22nd of January,
Yes.
2020.
The statement of Mr. Pule Joseph Motibe. I don't think it's got a date, or it does have a date, dated 22 January 2020, is admitted together with its annexures as Exhibit DD 19A. Now, the other statement, or is it an affidavit, that one?
No, that one is also a statement.
Oh, I just saw on page 31 saying affidavit, so.
Yes, sorry,
Oh, that's
that's,
somebody else. No, I'm sorry. I think that is somebody else.
that's another person's affidavit.
another
That's from Ms.
person, yeah.
Masasa. We'll come to that.
Supplementary statement. Now, from what you said earlier on, I think you intend that we take this as a separate exhibit rather than an annexure through the other statement, or?
Chair, my suggestion is that we keep it in Exhibit 19A because it's been
Yes.
separately identified by its pagination numbers,
Yes.
30.1 to 30.6.
Yes,
So I'd like to suggest we keep it in Exhibit 19A because that's how the referencing for my questioning today has been prepared.
Yes. It might not be mentioned as an annexure because it's a separate statement.
They are separate, yes. So it might be his supplementary statement which appears from page
Yeah.
30.1 to 30.6.
Yeah. Now, I see there is an affidavit later on. That's not an annexure to anything?
No, these
also?
are, once you finish this,
It will be an annexure to The first statement?
No, it's actually now the additional documents.
Oh,
So
okay.
once you complete the second statement, or what we're calling the supplementary statement,
Yes.
the remainder of A continuing into B is all the additional documents that have been produced and
Yes.
discovered in the course of the Commission's investigations, but they're
Yes,
pertinent to Mr.
yes,
Motibe's evidence.
yes.
They do include affidavits of others, and when I was going
Yes.
to come to them, I'd explain the circumstances for their
Yeah.
inclusion. None of them are contentious. But from page 31 then in DD 19A, it's a series maybe load shedding.
I think that I think it should be sorted out very soon. They previously promised that if they load shedding, they will bypass us so that we continue. easy, but if it's documents that are not annexures,
Yes.
they might need to be separately identified or admitted as exhibits in their own right.
Yes.
So, which we can do because we can say Mr. Motibe's statement is Exhibit DD 19A, and then
Yes.
we say BCD
Yes.
up to wherever.
Yes.
Would it be easier to do that immediately, or
I think
as you refer
as
to
we
each
go.
document? Yeah.
What I'm going to ask, Chair, is that I just be assisted. There's a new member of the legal team, Ms. Amy Armstrong, who's assisting me today.
Yes.
She'll be presenting evidence tomorrow.
Yeah.
If she can just keep a running list for me of where we are in the alphabet.
Yes. No,
Then
no,
as
that's
and
fine,
when
yes.
I refer to a new document,
Yes, it
we
can
will
be-
enter it
yes, yeah.
appropriately. Yes.
No, that's fine. So, as I have already indicated, Mr. Motibe's statement dated 22 January 2020 is admitted as Exhibit DD 19A, together with its annexures. I think it's got a few annexures. Is that
Correct,
right?
correct.
Yes. And then I think what comes after that, I think the annex shall probably go up to just before the supplementary statement.
That's exactly right, yes.
Maybe we may as well just deal with the supplementary statement
Yes.
as well.
That's not a problem.
So, Mr. Motibe's supplementary statement, it's undated supplementary statement, undated supplementary statement. It reads supplementary statement by Mr. Pule Joseph Motibe concerning joint audit of South African Airways Group's SOC Ltd SAA will be admitted as Exhibit DD 19B. It appears on page 30.1. And then others we will
Indeed.
deal with as we go along.
Certainly.
Okay.
Thank you, Chair. I'm indebted.
And then what will be necessary to do is that on the spine of the file, it should be
All the-
reflected what exhibits
Indeed.
are inside here.
Certainly.
Okay, all right.
Thank you,
Thank
Chair.
you. Yes.
Mr. Motibe, then to commence. If you can just put your microphone on. I understand there's no difficulty with you leaving it on, and it's just easier, then you don't have to worry about turning it on and off in the questioning. Mr. Motibe, if we start with your first statement, you'll see it begins at page 2 and it runs to page 14 of Exhibit DD 19A. Can you confirm that that's your signature on page 14?
Did you say it starts from page 2?
Page 1, if I said 2, that was an error. It's certainly from page 1 to
Yeah.
page 14. Thank you, Chair.
Chair, that is my signature.
And can you confirm that the contents of the statement are true and correct?
The statements in the comments in the statements are true and fair, Chair.
And are there any corrections you'd like to make to the statement?
There are no corrections.
Thank you. Mr. Motibe, can I just suggest for your convenience that you move, yes, I think it'll just be a little bit easier for you. And it also just helps to amplify your voice.
Thank you.
And then there is your supplementary statement, which we've admitted as Exhibit DD 19B, and that runs from pagination 30.1 to 30.6. Do you see that?
Yes, I do, Chair.
And can you...
I'm sorry, Ms. Hofmeyr. I'm concerned that for some reason, I don't know whether it's the mic, whenever you mention the page number of that statement, I always hear 50.
I don't know. Maybe I must try and
So,
articulate a little bit more clearly.
I'm wondering whether the transcribers are here.
Yes, let me-
30 or 50.
50. Let
Otherwise
me
they
be-
write the wrong thing.
Let me be clear, it's 30 with a 30. So it's 30.30.1 to 30.30.6. Do you have that, Mr. Motibe?
I've got the statement, Chair.
This was not signed. That is not a problem. I understand the challenges under lockdown when you were producing this. Can you simply confirm for us under oath today that its contents are true and correct?
The contents are true and correct, Chair.
Yes, thank you, Mr. Motibe. I'm concerned your voice is quite soft. I don't know whether it's because of the mountain of files next to you, or do you want to try and raise it?
I will raise my voice, Chair.
That's much better, yes,
Thank you, Chair.
Thank you.
And just to check, there are no corrections that you'd like to make to that statement, are there, Mr. Motibe?
There are no corrections, Chair.
Thank you. Mr. Motibe, I'd just like to start with some background, if we may. You indicate in your first statement, that's in Exhibit 19, DD 19A at page 1, that you are a registered auditor. Is that correct?
That is correct, Chair.
Can you tell the Chair when you completed your articles?
Chair, I completed my articles at the end of December 1995.
And what qualifications do you hold?
I've got a Bachelor of Commerce degree and a higher diploma in accounting.
And when did you become a partner at PwC?
Chair, I was admitted to partnership on the 1st of July 2003.
And when did you take over as audit partner for the SAA group of companies?
I took over as partner on South African Airways group of companies for the 31 March 2014 financial year.
And did you remain in that position until the 31 March 2016 audits were completed?
That is correct, Chair.
And how many years did PwC in total audit the SAA group with its audit partner, Nkonki Inc.?
Chair, it was for a period of 5 years.
Thank you. I'd then like to move to the topic of the requirements for auditing state-owned enterprises and talk a bit about auditing procedures. Could you tell us who designs the auditing procedures for an audit, Mr. Motibe?
Chair, the audit procedures would be designed by the audit team, that is the audit firms that are executing the assignment.
Now, in the course of preparing for your evidence, Mr. Motibe, you provided to the Commission some of the working papers for those audits that you still retained as PwC. And we took a look at those and tried to decipher from them what sorts of procedures you and your team had devised for the audits that you conducted at SAA. And so I'd like to check with you if we are correct in understanding that one of the things that you would do in your procedures was to study the minutes of meetings that took place within SAA. Is that correct?
Chair, one of the procedures that we do carry out is the review of minutes of boards, audit committees, and other relevant committees.
Thank you. So you've mentioned the board, so you would consider board minutes, would you?
Chair, that is correct.
And would you consider the minutes of the Bid Adjudication Committee as one of the committees?
Chair, that will be considered by the team that is carrying out work in a specific audit area. It may be one of the areas that they look at, but there are other areas, minutes that they will also consider.
Yes, I don't have a difficulty with there being other ones as well. I just want to get clarity on whether it would be part of the audit procedure to consider Bid Adjudication Committee minutes.
Chair, to the extent that it is relevant, yes.
When would it be relevant?
Chair, if one is looking at a contract and they may be following procedures relating to approvals.
Mr. Sokombela, in his evidence on the 21st of February 2020 this year, Chair, I don't suggest we go there. I'm just for the record going to give you the reference. It's in the transcript at page 103, lines 8 to 10. He said that his team certainly considered bid adjudication committee minutes. Would you agree with him that it's good audit procedure to look at those minutes amongst others?
Chair, I don't think it would be necessarily appropriate to comment on the work performed by Mr. Sokombela. I'm comfortable to comment on audit matters as far as it relates to work that I had performed. Otherwise, I'll be speculating, Chair.
Let me ask you, Mr. Motibe, then, do you regard it as a good audit procedure to consider the minutes of the bid adjudication committee at a state-owned enterprise?
Chair, in as far as it would be relevant to the area being tested, it would be a good procedure.
And if you're testing supply chain management and its compliance, should you be looking at bid adjudication committee minutes?
Chair, it would make sense to look at bid adjudication minutes.
Mr. Motibe, would you also, as your audit procedures, be reviewing media reporting about the entity that you're reviewing and auditing?
Chair, it is not a requirement of the standards, auditing standards, to look at media reports when one is performing an audit.
Did you say it is not a requirement?
Chair, yes, it is not a requirement, Chair.
Did you look at media reports in your own audit procedures?
Chair, we did look at media reports to the extent that we could find what we could find.
Yes, Mr. Motibe, you actually looked at them quite extensively, as I understand it. And for that purpose, I'd like us to go to a document that, Chair, you'll currently find, and Mr. Motibe, you'll currently find in the file that on the spine is numbered DD19B. Chair, I'm just using that reference so that you can find it. I'm mindful of your request that we now enter them as separate exhibits. But if you go into DD19B at page 443, do you have that, Mr. Motibe?
Chair, I do have the...
Now, we're going to enter this as the next exhibit, but I'd like you just to explain to us what this document is.
Chair,
1 second.
Apologies, Chair.
Please don't forget the question. I'm just wondering if we are going to enter it as the next exhibit.
Yes.
Normally, one would prefer to have that sequence where
Yes. You see,
under A, it's sequential until we
Yes.
go to B, to the next lever arch file. I'm just thinking, but of course, what you can do is that we could go to various exhibits in both files, even though we end up with, for example, D being in the first lever arch
Yes.
file and E being
Yes.
next.
Yes.
But later on, you could put them in one lever arch file, the one set,
yes, yes.
to be sequential. and then create another one that is sequential. That could be done.
We could certainly, Chair, the only
Yeah, but there
challenge
may be another way of doing it.
for today's purposes, my difficulty is the only way that I can direct all of us to the page I'm interested in is by its current pagination.
Yes, yes.
So, and that was
yes.
devised assuming that we would use the method that we'd been using previously, which
Yes.
was the DD19A for the
Yes.
first file, DD19B for the second
Yes.
file, and
Yes.
sequential pagination
Yes.
throughout.
Well, I'm wondering whether we shouldn't be creative and give these two lever files bundle numbers, even if the bundle numbers are not necessarily sequential
Yes.
to whatever other bundles
Yes.
have been given,
Yes,
so that we can say exhibit so and so isn't bundle
yes,
that, and we
yes.
say bundle so runs from page whatever to page whatever. Do you think that might?
I do think so. I mean, the
Yes.
simplest way for today's purposes
Yeah.
might be to, all that you've entered so far is DD19A and
Yeah.
DD19B. Those are the
Yes.
two statements,
Yes.
right? My suggestion is that we then say that DD19C will be the documents running from, and then I'll give you the pagination
Yes,
now.
yes.
It will be, I think I can remember, page 31 to page 250.
Yes, yeah.
And then DD19D will
Yeah.
be from page 251 to page 6, I just have to get it here, 624.
Yes,
Because
yes.
then we're going to be set for the day.
Yes,
Then I
yes.
won't have difficulty, then I can take you to the
Yes.
number.
Yes.
Will that be convenient,
Yeah, that
Chair?
would be fine. Let's do it that way.
Super.
Do you want to?
I'll just repeat it if
Yeah.
I may. So we've entered DD19A and DD19B into the record. We would then be entering DD19C into the record, and that will run from paginated page number 31, that's 31, to paginated page 250, 250.
I'm sorry. Did you say 19C or D?
C.
C,
Yes.
yes. C, that is at page 31
Yes, until page 250.
until page 2. Is that up to the end?
Correct, yes.
Or end of the second lever arch file?
First lever arch file.
Or end of the first lever arch file? Yes, okay, so that will be, all of those documents
Yes.
will be admitted as Exhibit 19C, and then they will be differentiated by a reference to the page numbers.
Exactly, Chair.
Yes,
That's going to be very convenient for
Yes,
us.
yes,
And then
yes,
just to be
yes.
clear for the record, what will then be entered as Exhibit DD19D for dog will be pages, you'll find that in the second file, Chair, and that runs from page 251 to page 624.
It's 2512.
To page 624, 624.
I think what we'll do is this could be done later on. might have to identify each document and maybe use APC or AA, PP,
Yes.
whatever. But for today's purposes, we will say that Exhibit DD19D starts from page 251 to 624,
Yes,
subject to later qualification and amendment.
certainly, with
Yeah.
the separate identification
Yes,
of the document.
yes,
Thank you, Chair.
yes,
We've made a
yeah.
note of that.
Yes, thank you.
So then just to take us back to where we were, Mr. Motibe, we are in what has now been entered as Exhibit DD19D, and we were at page 443, and I was asking you to help us identify this document. What is this document?
Chair, as part of maintaining our understanding of the client, we use information that comes to our attention.
I'll
Whilst,
ask you to raise your voice again.
apologies, Chair.
Yes.
Whilst it is not a requirement of the standards to go through the media to obtain such, Chair, to the extent that there are articles which have a bearing on our client and provide us information that helps us to obtain an understanding of our business and what is going in there, which helps us in confirming our risk-based audit approach. And we certainly do take account of those articles. To go out and it would not be possible to go out and search, because there is quite a universe of articles out there, Chair, and you will not be able to identify every single one of them. So to the extent that we identify articles that are relevant, we do look at those.
Ms. Motibe, was it part of your audit procedure to look at media articles related to the SAA group?
Chair, as part of our audit procedures, we looked at those media articles that came to our attention.
Yes, you say at page 442, under the heading Purpose of EAG, in accordance with the risk-based audit approach, we stay up to date with media.
I'm
Apologies,
sorry.
Chair.
My 442 is a
Sorry,
table.
443, Chair.
443.
443, apologies.
Okay, yes, okay.
I was reading from the words that appear under the heading just after the table at the top, the purpose of the EGA, but let's look at the table first. This relates to the engagement for the SAA group audit for 2015. Is that correct, Mr. Motibe?
That is correct, Chair.
And so the period end date of that audit is the 31st of March 2015. Is that correct?
That is correct, Chair.
It says audit unit in the next line, SAA Group Audit 2015 HQ. What does HQ stand for?
That's head office.
Headquarters, maybe, I don't know. Is that
Yes,
it?
headquarters, head office. That is correct, Chair.
And it says EGA title. What does EGA stand for?
There is engagement gathering evidence.
Right.
There is Chair, there is a PwC acronym that we use, Chair.
So this is how you acquire audit evidence. Is that right?
Amongst others, Chair, this is one of the ways that we
Yes.
would acquire evidence.
Yes, the audit evidence that's going to inform the audit that you conduct, correct?
That sounds correct, Chair.
And then under the purpose, there is the following. I'll read it into the record. In accordance with...
I'm sorry, Ms. Hofmeyer. Did you say EGA represents one of the ways in which you acquire evidence?
Chair, EGA, it's an acronym we use in PwC, which relates to sort of, if I recall...
Maybe you can start by telling me what E stands for, G and A, then that might help me. Or it's just Or there is no particular full name for it or full?
Chair, if my memory serves me right, Chair, it should be evidence gathering activity, Chair. So
Oh, that helps. That helps. Yeah. Okay. So no, then I understand.
yes, Chair. Thank you, Chair.
Okay.
And when you describe then later below the table on the page the purpose of your evidence gathering activity, you describe it as follows. In accordance with the risk-based audit approach, we stay up to date on media reports pertaining to SAA and to evaluate the effect thereof on the financial statements, identify risk, and therefore update our audit approach on a continual basis when necessary. Do you accept the accuracy of that statement about the purpose of your evidence gathering activities?
Chair, that is how the purpose reads, Chair.
Mr. Motibe, you were present for the evidence of Mr. Sokumbele, is that correct?
Chair, I was present for part of the evidence.
Have you considered the whole of his evidence before giving evidence today?
Chair, I've had a look at Mr. Sokombela's evidence. I've briefly had a look at that, but not probably in that kind of detail, Chair.
But were you aware then that he emphasized that looking at media reports would be an important part of and did form part of the approach that his team took to the audit in 2017?
Chair, as I indicated earlier, it is not a requirement of the standards for one to look at media reports. However, and as we have also done during our years under review, we did look at media reports that came to our attention and those that had an impact or provided information that could prove useful when we audited the client.
Are you aware that it's part of IRBA's guide on reportable irregularities that you should keep abreast of press reporting about the entity that you're auditing?
Chair, could I ask Ms. Hofmeyr to repeat the question? I'm not too sure that I understand what...
Sure. Are you aware of IRBA's guide regarding reportable irregularities?
Chair, I am aware of IRBA's guide relating to reportable irregularities.
Do you seek to act in accordance with it when you audit companies?
Chair, we act according to the guide at all times when we audit our clients.
Are you aware that the guide indicates that auditors should be considering press articles about an entity when they are auditing it as one of the means by which you are assisted in identifying reportable irregularities?
Chair, I would have to remind myself of that, but certainly, Chair, we did consider media reports relating to South African Airways Group of companies when we carried out our engagement.
Thank you. Mr. Motibe, in my introduction today, I indicated that when an auditor audits a state-owned enterprise, there are additional obligations on that auditor as compared with when the auditor simply audits a private company. Do you agree with that statement?
Chair, as I've indicated in my statement, Chair, can I refer Ms. Hofmeyr to...
You may refer to your statement.
Oh, certainly. You'll
Thank you,
find that in DD 19A, and it commences at page 1.
Thank you, Ms. Hofmeyr. Chair, on page 1 of my initial statement, on DD 19 PJM 01, at the bottom of the page, Chair, the last paragraph, we confirm there the auditor's duty.
You can read that paragraph if you want to.
Thank you, Chair. The auditor's duty in a statutory audit is to provide an opinion concerning whether or not the annual financial statements fairly present the entity's financial position and the results of its operations and cash flow information in conformity with generally accepted accounting practice. So, Chair, that is our primary role as auditors. And we are also required to comment as to whether the report would confirm that the financial statements are prepared in accordance with the requirements of the Companies Act. When we audit state-owned enterprises, we do so on behalf of the Office of the Auditor General. And he has issued guidance which require us to also consider matters of compliance with laws and regulations, which, by the way, Chair, is a requirement of the auditing standards. So, Chair, much as there are additional guidelines from the Office of the AG, they are in fact covered by the ISAs when it comes to, because you are required to consider compliance with laws and regulations in terms of, I think it's ISA 230, Chair, I'll have to confirm the exact numbering. But Chair, the audit standards sufficiently cover that, Chair.
Thank you, Mr. Motibe. I'm grateful for your clarification on that point. If I can direct you to paragraph 9 on page 2 of your statement, which for reference purposes is in Exhibit DD 19A, you'll see a paragraph 9 there. You sum up, I think in essence, what you've described now to the Chair. You say for all audits, the auditor is required to comply with international standards of auditing, known as the ISAs. That's what you were referring to a moment ago. Is that correct?
Chair, that is correct.
And then you go on, you say the ISAs require the auditor to consider relevant and applicable laws and regulations that may have a material impact on the financial statements as a whole. I take you to the point you made earlier, is that applies whatever company you're auditing. Is that correct?
Chair, that is correct. If I may give an example, Chair, when you auditing a bank, Chair, there are additional requirements in terms of the Banking Act. So you'll have to bring that into consideration. When, Chair, you are auditing an insurance company, there is legislation specific to insurance companies that you have to consider. So when you audit state-owned enterprises, it is then the PFMA that is brought into the picture. So in essence, Chair, an audit is an audit. There are no peculiarities, Chair, or there are no additional requirements in terms of auditing state-owned enterprises, because all the standards that requires you to look at applicable laws and regulations covers that, Chair.
And you'll accept, as you just have, that one of the key pieces of legislation for state-owned enterprises is the Public Finance Management Act, correct?
Chair, that would be correct.
So let me go back to the point you made just before you answered this question, because it seemed to me that it was suggesting that it might not be accurate to say when you audit public enterprise, there are additional requirements that are not there when you audit a private company. That's the impression I got from your answer. Is it a correct impression from the comment you made? When
Chair,
you said an audit is an audit.
Thank you, Chair, for the question. Chair, I think what I was trying to illustrate, Chair, is that we carry out our audit in terms of international standards of auditing. And even when you audit in the public sector, you still comply with the international standards of auditing. To the extent that there are additional requirements in the PFMA, It is not necessarily an initial requirement. It does not mean that the audit itself is necessarily different from what is in the private sector. It's more if I can use the term, Chair, it's more an industry issue. Different industries have got different requirements, and one would then look at the public sector as as an industry, and you say the PFMA is then the kind of regulation that you'd look at when you audit a public entity or a state-owned enterprise, as it is, Chair.
It may be that it's a difference without distinction.
Indeed, Chair.
Okay.
Because certainly the PFMA won't apply to a private company, isn't it? But it will apply to a lot of these SOEs that certainly this commission has been looking at, and government departments. But you seem to choose to look at it not as an additional requirement, but you simply, you prefer to approach the matter on the basis that each industry or sector has got its own features. And when you are auditing an entity, whether private or public, in a certain sector, in a certain industry, you have an obligation to comply, to look at everything that applies to that sector. If it's a public sector, you would include the PFMA. If it's in the private sector, you won't include the PFMA, but depending on which sector it is, like insurance or whatever, there may be specific legislation applicable to that category of entities or that industry. And you as an auditor will have an obligation to apply your mind to all of the relevant legislation. That's how you approach it.
Yes, Chair, that is correct, Chair.
Yeah, okay.
Thank you, Chair. We're indebted for that clarification. I would then like to take you, Mr. Motibe, to the PFMA, because there are a few provisions there that are going to form a backdrop to some of the questions today. Mr. Motibe, you'll find that in the file that's been made available to you in this box of files entitled Aviation Legislation. Chair, we have dealt with that file previously. If I can just ask your registrar to assist you with the aviation legislation file. Chair and Mr. Motibe, you'll find the Public Finance Management Act in that file commencing from page 4646.
Shall we identify this? I think this is the file written Exhibit DD, Aviation Legislation Reference Bundle on the SPY.
Thank you, Chair.
That's the file we are.
Yes, and
looking
it has been entered into the record previously.
Yes, yes.
That's helpful. Thank you.
Yes,
And then
I
we
just want to
commence
make sure that whoever reads the
Indeed.
transcript knows which file we are now
years
talking about.
after,
Yeah.
we assume.
Yes, yeah.
And
Okay.
we start with the PFMA, which commences at page 4646. Mr. Motibe, are you familiar with the provisions of this Act?
Chair, I have read the Act previously, and I'm familiar with some of the key provisions in the Act, Chair.
The first provision within the Act I'd like us to look at appears at page 50, and it's the definition of irregular expenditure. Could you read into the record what irregular expenditure is defined as on that page?
Chair, irregular expenditure means expenditure other than authorized expenditure incurred in contravention of or that is not in accordance with the requirement of any applicable legislation, including this Act or the State Tender Board Act 1968, Act number 86 of 1968, or any regulations made in terms of that Act, or any provincial legislation providing for procurement procedures in that provincial government.
Mr. Motibe, do you understand from that definition that if a state-owned enterprise incurs expenditure which is not in accordance with the requirements of the PFMA, it will constitute irregular expenditure?
Chair, that is well understood, Chair.
Thank you. And then if we go to section 51.5.1, which you'll find at page 68.68. This is where we start to get to the substantive provisions of the PFMA that regulate state-owned enterprises such as SAA and its group of companies. And what section 51 does, Mr. Motibe, and I'd like to confirm that this is also your understanding, is that it sets the responsibilities of accounting officers of state-owned enterprises such as SAA. Do you agree with that?
Chair, that is correct, Chair.
And amongst those responsibilities, could you tell us what the responsibility at section 51(1)(a)(1) is?
Chair, if I read it out, it says effective, efficient, and transparent systems of financial.
Your voice has gone down again.
I'll come closer to the mic, Chair.
Okay, all right.
Effective, efficient, and transparent system of financial and risk management and internal control.
So it's a requirement, is it your understanding that it's a requirement of the PFMA that an entity like SAA must ensure that it has and maintains internal controls?
Chair, that is correct.
And that it has and maintains an effective, efficient, transparent system for financial and risk management?
Chair, that is how the Act reads. That's correct, Chair.
And is it also your understanding that it's another obligation of the accounting authority for an entity like SAA to have and maintain, I'm now at Roman 3, an appropriate procurement and provisioning system which is fair, equitable, transparent, competitive, and cost-effective?
Chair, that is how the Act reads. That's correct, Chair.
And that's your understanding of it, is it, Mr. Motibe?
Chair, that is my understanding.
Thank you. And who is the accounting authority for SAA?
Chair, that would be the board, and obviously the board may delegate it to the CFO and other relevant officials.
Would that happen by way of delegations of authority?
That would be correct.
And then if we go over the page to page 69, the other obligation or responsibility of accounting authorities, I'd like to just be clear that we're on the same page about, is the responsibility for the accounting authority to have and maintain, apologies, now we're on to B, I'm interested in B, so the accounting authority of a public entity, B, must take effective and appropriate steps to, Roman 2, prevent irregular expenditure. Is it your understanding that the board of SAA was required to do that as well?
That is correct, Chair.
Thank you. I'd then like to go to section 55, because that's actually the section I suggest slightly closer to home for you, because that is the section, you'll find it at page 70, Chair and Mr. Motibe, 70, and it's section 55, which deals with the annual report and financial statements of public entities. And the one I'm interested in there, Mr. Motibe, is section 55(2)(b). Section 55(2)B reads as follows: the annual report and financial statements referred to in one of the subsections above must, and B, include particulars of Roman 1, any material losses through criminal conduct, and any irregular expenditure and fruitless and wasteful expenditure
due to a certain contract that SAA awarded to Mr. Motibe. Okay,
Yes, Chair.
so you want to look at how that contract was awarded.
Yes, Chair, that is correct.
Would you, once you have identified that contract as one of the matters that you must look at, would you then go through the various stages or requirements to say SAA was required to do A, B, C, D for this contract to be said to have been awarded properly? Did they do A, B, C, D properly? And if you then concluded that that was done properly, then you say, okay, I've taken care of this. Or would you, for example, despite knowing that SAA was supposed to do A, B, C, D, would you just look at A and B, and if you are happy with A and B, you don't look at C and D?
Chair, what you have described, in order to understand what Ms. Hofmeyr is looking for, we have done that, Chair.
You did that, so you would look at A, B, C, and D,
Yes,
so
Chair.
to speak. Okay, all right. I hope that has
Thank you.
helpful.
It does. Ms. Motibe, how did you do that if you couldn't find the tender files?
Chair, as I indicated, Chair, for the samples that we had selected, we followed that through. And where there were challenges and there were deviations, we found them and we raised them with management and with the audit committee, Chair.
Does that suggest that you found files in regard to all the contracts you looked at? Because I think Ms. Hofmeyr's question is, how would you have looked at A, B, C, D in my kind of example if you did not find the files?
Chair, thank you, Chair. Chair, if one looks at the report that we sent through to management and to the committee, we did mention areas where we could not be provided with files, and therefore we would obviously not have been able to complete that process. Hence, Chair, I do indicate we followed the guidance on how to perform the audit of procurement and contract management. Where we found the files, we obviously able to perform every single test, but there were areas where we could not be provided with the files. And so the test failed, and we reported that matter to management. We asked them to follow up, and we reported the matter to the audit committee.
Would it be correct to say, without the files, you couldn't perform that job, your job as an auditor?
Chair,
properly.
Yes, Chair, without the file, then you are not able to complete all
Yes,
the necessary steps. That is correct, Chair.
You can comment about the absence of the file or not being provided by the file, but you can't actually do what you are supposed to do without the file. You can't perform the actual job that you wanted to do.
Chair, that is correct.
Yes.
And it was for that reason that we elevated, we
Yes.
raised the issue with management,
Yeah.
and we elevated the matter to the audit committee. And Chair, I think as I allude to in our summary statement, we acknowledge that we should have, there was that next step of, in the audit opinion, mentioning those non-compliance issues with the PFMA.
Ms. Hofmeyr.
Yes, it's that step that is quite an important one, isn't it, Mr. Botibe? Because it's one thing for you to need to do the work that's required of you, to find that you're inhibited in doing that because you can't find tender files, to report that to management and the Audit and Risk Committee, but then not take it any further. That would be a dereliction of your duty, wouldn't it?
Chair, I would not go as far as to say it's a direction of duty, because we certainly there are reporting steps that we're able to carry out, Chair. And as I do indicate, Chair, we did consent to the fact that that last step should have been carried out. That
Yes,
is identifying the matter in the audit opinion.
Yes, but if it was your duty to do that last step and you didn't do it, why is that not a dereliction of duty? Because I think you don't concede to Ms. Hofmeyr's question that when she asked, was it not a dereliction of duty? So my question is, since you do accept that that last step should have been done, and it wasn't done. So my question is, which is basically Ms. Hofmeyr's question, why was that not, why do you not regard that as a dereliction of duty?
Chair, can I think about that? Because I guess, Chair, I'm trying to wrap my mind
Okay.
around
No,
what exactly the direction of duty, because it could
Yes.
it could mean something else, Chair.
Okay, well,
And I'd like to wrap my
no,
mind around Chair.
that's fine. Ms. Hofmeyr can come back to it later on if, yeah.
See, the problem with that last step, Mr. Botibe, I'd like to put to you and have your comment on, is if you don't focus on and perform your duty in the last step, then your audit opinion is going to be incorrect, isn't it?
Chair, the audit opinion, insofar as it talks about compliance with laws and regulations, Chair, would be incorrect.
Because you can't satisfy yourself that there's been compliance because you haven't got the tender file. And although you've reported it to management and ARC, the Audit and Risk Committee, you didn't receive any meaningful response to that, did you?
Chair, in performing the work and in identifying the issues and elevating them to the audit committee, we had already identified that it is in fact non-compliance with the PFMA. As I do indicate, Chair, that last step is what was missing. That's where we erred in not informing the shareholders in that regard.
Ms. Hofmeyr, please don't forget your next question. I just want to go back to the dereliction of duty aspect. If we don't call it dereliction of duty, but call it omission of duty, are you comfortable to concede that?
Chair, it was an omission.
It was
Chair.
an omission
It was
of
an
duty.
omission.
Okay, all right. Thank you. Ms. Hofmeyr, that doesn't preclude you from coming back
Of
to the
course.
question, but I thought I would, yes.
Thank you, Chair. Chair, I note that we are close to the tea break, but I would like to just conclude on one point, if I may. Ms. Motibe, I understood your last answer before the Chair's question to be that you had identified non-compliance, you'd raised it with management and the Audit and Risk Committee. But then I want to put to you, if that is so, and you aren't satisfied that there has then been compliance because of the response you get, it is then misleading to the public, is it not, to sign an audit report which says that there has been compliance. We do not identify any instances of material non-compliance with applicable laws and regulations. Do you accept that?
Chair, after we've completed our work, when we put our audit opinion together, we considered all the evidence that had been provided for audit purposes and applied judgment on some of these issues of non-compliance and other matters, in fact, Chair, in the audit as a whole. And at that stage, Chair, our view was that there was no material non-compliance. And I think, Chair, it is important to note that we're not saying that there was no compliance. I guess, Chair, we say that there was no material non-compliance. Chair, again, I would refer one to the supplementary statement, because we do concede that there was an error in judgment. We should have identified those matters as material areas of non-compliance.
Yes, and so then when you stated in your audit report, we did not identify any instances of material non-compliance with applicable laws and regulations, that was misleading.
Chair, that portion, Chair, was not correct, Chair, yes.
Thank you, Chair. I see we're just at 1:15, if it's a convenient time to take the break.
Yes, we'll take the short adjournment. We'll resume at 11:30. We adjourn.
All rise.
of PwC and Nkonki's appointment to audit SAA. And I've looked at your statement and what it says on this topic, and it may be that we can move fairly swiftly. That will depend on whether you and I are on the same page about certain aspects up front. So let me ask, first of all, do you accept that the tender process that was run by SAA for the appointment of auditors for the 2012 financial year applied only to that year?
Chair, I think I've said that my understanding was that it was for a period of 5 years, if my memory serves me right.
But you've now been shown the documents that show that it was a tender for only 1 year. Is that correct?
Chair, I've seen the award letter which talks of and the audit being awarded for 2011-2012 financial year.
So as you sit here today, do you accept that they were only awarded, they being PwC and Nkonki, were appointed for only 1 year pursuant to a tender process?
Chair, my understanding was that we were awarded the tender for 5 years. However, it is subject to annual concurrence by the audit committee, by the Auditor General. And that appointment has got to be confirmed annually by the company at the annual general meeting as required by the Companies Act.
Ms. Mothibe, how could you form that view based on the tender, the award letter?
Chair, as I did indicate in my statement, the appointment of PwC and Nkonki predates my joining the South African Airways or rather PwC audit team. When I took over the assignment, I understood that the award was for 5 years, but also understood very well that it is subject to annual concurrence by the Office of the AG and confirmation at every annual general meeting by the client, because the client reserves the right to review the appointment, Chair.
But I think Ms. Hofmeier's question is whether, as you sit there today, you accept or you don't accept that the appointment was for 1 year. So distinguishing it from what you may have understood when you joined the team.
Chairman, the award letter said 1 year, and Chair, from my understanding, it's 1 year because it had to be renewed on an annual basis, but the term would have been for 5 years. So the appointment has to be confirmed by the client at the AGM and has to seek concurrence from the Office of the AG.
So is your evidence that you don't accept that the appointment was for 1 year?
Chair, I'm not too sure that one can read that letter as plainly as that, because my understanding, Chair, is that they have to. You can't appoint for more than 5 years, for more than 1 year. You have to seek concurrence and approval at every AGM. So the appointment letter should, as I understand it, Chair,
yes,
would list that 1 year that you appointed, and then once there's concurrence and approval, then another one that confirms the next year, as it is, Chair.
I think Ms. Hofmeier will take us to the actual letter, and then, yes, Ms. Hofmeier.
Thank you, Chair. Ms. Mothibe, I had hoped that we would be able to move through this quickly, but it appears that we're not going to be. Do you know that the request for proposal to which PwC responded related only to an audit for the 2012 financial year?
Chair, maybe if Ms. Hofmeier could give me a reference to the file.
Yes.
Let's find it in,
Yeah.
it's in DD 19C, as we've now numbered it, from page 59.
I've got it, Chair.
Now, that is a document, as appears at page 59, bid document, request for proposal for the provision of external audit services to SAA Group. Do you see that?
I see that, Chair.
And then if you turn to page 77, you'll see there the scope of work is identified. Do you have that?
I see that, Chair.
And in the second, it tells you that the objective of the audit as a statutory requirement is the expression of an opinion on fairness in all material respects of SAA's financial statements in conformity with international financial reporting standards. And then the second sentence says the audit for the financial year ending 31 March 2012 have to be conducted in accordance with the international standards on auditing. And then it gives you the focus areas for the audit for the financial year ending 31 March 2012. Do you see that?
That is correct, Chair.
Do you now accept that the request for proposal related to the audit for the financial year ending 31 March 2012?
Chair, that's how it reads, Chair.
You accept that, and then that was followed up by the award letter to PwC that was clear on this point. You'll find it at the same bundle, page 115.
I've got it, Chair.
This is a letter of award to PricewaterhouseCoopers from the Chief Procurement Officer of South African Airways. It is dated 21 December 2011. Please, can you read the first paragraph of the letter into the record?
The one that starts with reference to the above.
Yes, indeed. Thank you.
With reference to the above request for proposal, South African Airways Limited, SAA would like to congratulate PricewaterhouseCoopers on being awarded the above services as joint external auditors within Nkonki Incorporated for our 2011-2012 financial year.
That is an award for 1 year, correct?
Chair, that's how it reads.
Yes, so do you now accept that PwC and Nkonki were only appointed for a single year after the tender process that preceded this letter?
Chair, that's how the letter reads, but I do believe it is important to note that companies don't change auditors annually. And from our understanding as PwC, certainly was that the audit engagement would be for a period of 5 years. Chair, it is not economically viable, certainly from our side, to respond to a tender, audit tender of this size, of this complexity, if it was only going to be performed for a period of 1 year. In the first year of engagement, Chair, there's a lot of investment that takes place with regards to understanding the client, the complexities that come with it. And Chair, as I do indicate, from a commercial perspective, you certainly would not be responding to an RFP of this magnitude if it was only for 1 year. Also importantly, Chair, running a tender process for audit services on an annual basis takes a lot of time, not only for respondents, but also for the client. And Chair, it would be very disruptive for a client to be engaging with new auditors every single year. As you appreciate, Chair.
Yes, Mr. Mothipe, I think both Ms. Hoffman and I understand what you are saying. I think another witness has said something similar. Okay. But the question is, irrespective of whether you consider it viable or not viable for an entity such as SAA to appoint auditors for 1 year, the question is whether you accept that in this case, the appointment was for 1 year, right or wrong, but that's what happened.
Yes, Chair, that I've agreed to, Chair. I thought it was important just to bring some perspective, Chair,
yes,
to the matter.
That's fine.
Ms. Motibi, then I would like to just pick up on something you were saying in that context setting. You, as I have it, you said something like, it would not make sense for PwC to respond to an RFP of this magnitude if it was not for something like a duration of 5 years. Did I have your evidence correct?
Chair, what I mean is any audit firm, I spoke PwC because obviously, Chair, I do work for PwC, but I would say it would not be commercially viable for any audit firm to respond, especially for a company this size, this magnitude, and this complexity. It would just be not viable if it was only for a period of 1 year.
Then why did PwC bid for 1 year?
Chair, goes back that our understanding was that it would have been for a period of 5 years, which is in line also with the rotation period of a partner as laid out in the Companies Act, Chair.
Mr. Motibe, how did somebody in PwC read a request for bid confined to 1 year, receive an award letter for 1 year, and form the view that it was getting to do audit work for 5 years? How does that happen?
Chair?
So in other words, what's the basis for you or PwC to have thought that this was for 5 years when the request for proposals was talking about 1 year and the letter of appointment was talking about 1 year?
Chair, as I indicated earlier, this was predated my involvement. However, Chair, it is standard practice, or it is practice that when you get an audit or an audit, it is for a period of longer than 1 year. We have not seen, Chair, anywhere where an audit was awarded for 1 year only, Chair. That doesn't happen in practice, Chair.
Ms. Hofmeyer?
Do you think PwC bid for 1 year and hoped it might be able to get extensions of that 1 year?
Chair, as I do indicate, we are also alive to the fact that to the extent that the subsequent years audits are with PwC, they will still be subject to concurrence by the Office of the AG and confirmation at the AGM. So there is still a process that is followed in that regard.
And what about the process of lawful procurement? Wouldn't PwC have to subject itself to another procurement process if all it was appointed to do initially was 1 year?
Chair, the procurement process is run by South African Airways and not by PwC. Chair, so I'm not too sure I can speculate on that regard, Chair.
Well, you said that, I'm putting it in my own words, I'm paraphrasing what you were saying, that there was going to be, or there were going to be annual renewals. So the question then is, shouldn't those renewals have been subject to a open public tender? And I think your answer is SAA would run that, but I think Ms. Hofmeyer probably wants to follow up on that.
I agree it's for SAA to run the process. What I'm trying to understand is PwC's thinking, because your evidence before this commission is it's not commercially viable for audit firms to bid for only 1 year's audit. Is that correct?
Yes, I said on this magnitude, and it is something that we don't see in practice.
Yes. And then I said, well, how then did PwC go about its approach here? Because it bids for 1 year, it gets awarded for only 1 year. And I've asked you, did it think it would simply be able to extend each year or get appointed for further years? And I understood your answer to be yes, because there's a process where the Auditor General has to yearly confirm his agreement with that appointment. Do I have your evidence correct?
Chair, as I indicated, the areas here which predate my involvement, but certainly the understanding was that the audit was for a period of longer than 1 year, subject to approvals.
Yes, but do you accept
Okay,
that if...
I'm sorry, I'm not sure that I understood that. Just repeat that last point.
I was saying, Chair, that my understanding, as I indicated, was that the award of the audit was for a period of longer than, not 1 year, but 5 years, and however, it will still be subject to approvals. And we do to take comfort in the fact that the Office of the AG gave concurrence after the company appointed PwC and Nkonki at its annual general meeting.
Mr. Motibe, do you accept that when a state-owned enterprise like SAA appoints an external auditor, it is procuring services?
It is a recurring service, Chair.
And do you accept that the procurement of services by a state-owned enterprise like SAA must be preceded by a tender process?
Yes, Chair, which tender process was entitled to in 2011 that we responded to? For
Yes, for a single year, Mr. Motibe. Is that correct?
Chair, I shared with Ms. Overa my understanding of what it was.
Maybe please don't forget your line of thinking, Ms. Hofmeyer. Let's put this to bed if we haven't done so. By which I mean, let's see whether there is agreement exactly on what the position was. We now know that the request for proposals was for one financial year, 2011, 2012, okay? And you accept that. But you say, if I understand you correctly, you had an understanding. You had an understanding that the appointment was for 5 years.
That is correct, Chair.
Subject to annual approvals or renewals. Is that right?
That's correct, Chair.
Now, where did you get this understanding from that the appointment was for 5 years when the request for proposal said 1 year, the letter of appointment said 1 year?
Chair, if you recall, I did indicate I was not part of the process. I became part of the audit team for the 2014 financial year. So we had already signed off jointly with Nkonki the 2012 and the 2013. So as part of the handover process, we discussed, we spoke about what our duty and our mandate was, and so it was confirmed that our understanding was that we were appointed for a period of 5 years.
So your understanding is based on what the team, the PwC team responsible for auditing SAA conveyed to you at the time?
And Chair, also what we have experienced, what happens in the industry.
Okay, well, certainly the team, the PwC team that was assigned to SAA conveyed that to you. That's number one. Number two, you say there's a practice in the industry that also informed your understanding. Is that right?
That is correct, Chair.
And what is that practice?
Chair, that typically when you appoint auditors, it would be for it would not be, certainly not for a period of 1 year only, Chair. And importantly, there is that annual reappointment approval at the AGM, annual general meeting of the company, which is a requirement of the Companies Act, Chair, that happens.
Is your evidence that the practice in the industry is that an auditing firm would be awarded a job such as this, and on paper it would be written 1 year, but everybody else knows that it's not going to be for 1 year, it was going to be for 5 years or 3 years. Is that what you are saying?
That is my understanding, Chair. That is what I'm saying, Chair.
So even if the entity makes it clear that this is for 1 year, you would take that you have been awarded a contract for 5 years.
Chair, I would think there'd also be discussions with the entity. Once you were appointed, you obviously would be engaged with the entity to understand the exact mandate, how long it is. But as I indicate, Chair, as the letter stands, I do agree it says 2012, because, and I do believe it should be because there is a requirement to have an annual reconfirmation by the AGM and by the AG.
Ms. Hofmeyr.
Ms. Motibe, I want to move you to a new document in a moment, but I just want to understand this practice in the industry. Is that a practice related to private companies or to state-owned enterprises?
Chair, even with private companies, we would, an audit firm would not respond to a request for proposals if the appointment would only be for 1 year. That would not happen, Chair.
Let me be clearer with my question. I can completely understand in a private company context why it would be the case that even though you're appointed for 1 year, you have some reliance on an industry practice that at the next annual general meeting you'll be appointed again. That is private companies. State-owned enterprises are regulated by the PFMA. They have to go out on tender before they procure services. And I'm trying to understand whether the industry practice to which you speak is also an industry practice for the state-owned enterprises who need to be audited. Do they generally roll over their audits when they go out on tender only for 1 year? Is it your experience that they continue to extend those?
Chair, I have not seen even the state-owned enterprises that that keep auditors only for 1 year. I have not seen that, certainly, Chair.
My
Well,
question
that's-
is different, but go ahead, Chair.
Okay.
Maybe you go back to your question before I ask.
I want to understand this practice because it's quite important in the state-owned enterprise context. Are you aware of a practice whereby state-owned enterprises run tender processes only for a year, but it is understood by the industry that that is for a longer period of 3, 4, 5 years?
Chair, I'm not too sure if I can answer that question because I can talk to requests for proposals that I had responded to.
Let me put it this way. You talked about a practice that you understand to be there in the industry.
Yes, Chair.
So Ms. Hofmeyr's question is whether that practice that informed your understanding,
Yes, Chair.
does it apply to state-owned enterprises? Or is this a question of you may have been aware of a practice that applies to the private sector, but you invoked it in the context of a public enterprise without knowing that in the public sector, without knowing whether there is such a practice in the public sector?
Chair, apologies for the delay. I'm just trying to reflect on what one has has observed, Chair. Chair, I do believe even in the public sector, an appointment of 1 year is, as I indicate, it's not one that I had seen, Chair. I've not seen that, and the expectation.
Yes, but the question is about the practice. So in other words, as you sit there, are you able to say this practice that I'm talking about exists in the public sector as well? Or is your position that you are not sure whether it exists in the public sector, but you know that it exists in the private sector? Is it the latter?
Maybe I'll say the latter, Chair.
Okay, all right.
Ms. Motibe, you made the point earlier, procurement is the responsibility of SAA, and I readily accept that. But what I'd like to just draw your attention to is that it is customary for SOEs to devise tender processes for the appointments of their auditors for 5 years. I suspect for the very reasons you've given, right? And the reason I say that with confidence is because we in our investigations have been able to find one of the tenders that Eskom put out, for example, in 2015 for its audit services, and you'll find that in DD 19C at page 149. Let me just be clear, it begins at page 143. It's the Eskom RFP. For audit
did you say
services.
149?
It starts at 143, Chair, just so that we can identify the
Yes.
document.
Okay.
This is the November 2015 Eskom RFP for professional services, including audit services. And if you go in it at page 149, I won't bore you with all the details of this RFP, Mr. Motibe, but it is an RFP for professional services, including audit services, and at paragraph 4.3 on that page, there are stipulated additional conditions of tender. And what Eskom does here, I suspect you might say is sensible, because Eskom says the appointment will be made for a period of 5 years relating to the audit of 5 financial years, from 2014 to 2015 financial year onwards, subject to the following conditions. And if you go to the last of the bullets there, this is the point that you've emphasized about the Auditor General. What Eskom does is it says the final condition is there must be annual consultation with the Auditor General before the appointment for a specific year is finalized. Do you see that?
I see that, Chair.
So what I put to you is there is a way for state-owned enterprises to procure the services of auditors for more than 1 year, and I'm suggesting this is an example of that. Do you accept that that's so?
Chair, this is a good example, Chair.
And it should be contrasted, I put to you, with the request for proposal that went out from SAA in 2011, because SAA's 2011 request for proposal looked nothing like this, did it?
The SAA RFP did not contain this clause, Chair.
And Mr. Motibe, you said that when you came in 2014, and I'm mindful to the fact that you were not there from the beginning, but when you came in 2014, you were led to understand that this was an appointment for 5 years. Is that correct?
That's the understanding that I had, Chair.
Yes. And you got it from your team, is that right?
That is correct, Chair.
And as part of the audit procedures that your team were following, were they reviewing BAC minutes and board minutes in the course of their audit procedures?
They would have done so, Chair.
So do you know why they didn't pick up a bid adjudication committee minute in 2012 that raised concerns about the fact that the appointment of the auditors for the 2013 year had not gone through a procurement process?
Chair, I was not part of the team in 2012, so I cannot comment on that, Chair.
In preparing for your evidence today, have you raised any questions with your colleagues about why they might not have picked that up?
Chair, as I did indicate, remember, Chair, we said that our understanding was that it was for a period of 5 years. So if one thinks about it, Chair, there would not be any adjudication because the audit would have been for 5 years, as we understood.
Well, you might have misunderstood the question.
Yes,
The question is whether in preparing for giving evidence today, you did pick up that the PwC team did not pick up the issue of there having been no open tender. Or unless I misunderstood you, then your answer, maybe you are saying your answer is you couldn't have picked that up because your understanding was that it was for 5 years, and if it was for 5 years,
it wouldn't be there.
the tender that had been done at the beginning would be applicable for all the years.
That is correct, Chair.
Okay, all right.
So what I'm trying to probe at the moment is how your team formed this understanding that it was for 5 years. Because part of the audit procedures is to look at minutes, right? And I want to now take you to the Bid Adjudication Committee minute that appears in DDC at page 117. This is, Mr. Motibe, do you have it?
I have it, Chair.
This is a decision record of a meeting of the Bid Adjudication Committee of SAA dated the 7th of December 2012. Do you see that at the top of the page?
I see that, Chair.
And in the second block on that page, there's a heading Project Description or Purpose. And what it records there, I'll just read it into the record, is to notify the BAC of the support and recommendation by the Audit Committee to the SAA Board of Directors of the extension and reappointment of PricewaterhouseCoopers and Conky Incorporated as the joint external auditors for the SAA Group, excluding Mango Airlines, for the 2012-2013 financial year, at an estimated cost of 16,838,850 rand. Do you see that?
I see that, Chair.
Now, that's the year after the year for which the tender process was run, correct?
That is correct.
And your team, as I understand the procedures, would have been looking at these minutes amongst others. And what I want to understand from you is how they could have missed what is reflected at the bottom of that page under the heading Conditions or Follow-up Actions. That's written in hand, and I'll read it into the record. BAC noted that the normal defined and approved procedures in line with SCM policy and DOA was not followed. The head of GSM should escalate to the internal audit as the process was not correctly followed. BAC, aware that this has been approved by the AGM and supported by the Audit Committee, business should clarify the original contract period and provide additional information on the process followed. How did the PwC team miss, when it was going through these minutes, this recordal, do you think?
Chair, this minute predates my involvement, so I'm not too sure that I'm able to do that. If I respond, Chair, I would be speculating.
Yeah.
And if I'm allowed to speculate, Chair,
Yeah.
it might be because it did not form part of their sample. Because once you do review minutes, and you review minutes and you pick up, you do pick up items from minutes that you'd want to audit. There's different criteria that you use to pick them up, and it could be that this matter, as related to the work that happened, was not part of the sample that they've looked at. But Chair, as I do, that's speculating, Chair.
Yeah, no,
it's not fair to do so, Chair.
That's fine. Let me ask this question. Bearing in mind that you were not there at the commencement of PwC's involvement at SAA, I take it that the team would not have started the work without the PwC team, would not have started the work without having seen the letters of appointment, or at least the leader of the team. Is that right?
That's correct, Chair.
Yes. And now that we know that the letter of appointment made it clear it was for one financial year, sitting there, are you able to understand how somebody who would have seen that letter saying 1 year would say to you, we have been appointed for 5 years? Now, I'm not suggesting that the person who told you is the leader of the team, but I'm just assuming that at least the leader of the team would have seen the letter of appointment. If he had seen the letter, would you have any understanding how he would say, or anybody who had seen it would say to you, we have been appointed for 5 years? You might be able to say, I don't understand why anybody who had seen the letter would tell me it's for 5 years. Or you might say, because of A, B, C, D that I'm aware of, I can understand why somebody who had seen the letter would tell me that the appointment is for 5 years. That's what I'm interested in.
Yes, Chair, I understand your question. Chair, the appointment was for 2011-2012, the initial letter. Subsequent to that, there was another appointment for the year 2012-2013. So when I became involved, we had also already been appointed for 2013-2014. Because as I did indicate, Chair, I only joined the team halfway during the 2014 financial year. So, as you can appreciate, Chair, with the passage of time and with the subsequent appointments post the first one, I can understand why the view was that it was a period of 5 years, because that appointment, the initial appointment, had been reconfirmed for another 2 years, Chair.
But if one is basing the statement that PwC was appointed for 5 years on what you are saying, it wouldn't be on the basis of the letter of appointment, isn't it? Saying that PwC was appointed for 5 years could not be on the basis of the letter of appointment. It had to be on the basis of something else, because the letter of appointment was quite clear.
Chair, a letter of appointment is issued on an annual basis, Chair. So for the subsequent year, there would have been another letter issued confirming appointment, same as all subsequent years, Chair.
Yes, but let's take it step by step. Do you agree with me that the letter of appointment to which we have made reference earlier on, which said 1 year,
That is correct, Chair.
could not form the basis for anybody to say PwC was appointed for 5 years? If there was a basis for saying that, it must be something else, not the letter. You agree with that?
I hear you, Chair.
Yes. And I seem to understand you to say there were annual letters of appointment, or I don't know whether that's what you would call them, every year. Now, would those annual letters be the basis for anybody to say PwC was appointed for 5 years?
Chair, as I indicated, that was my understanding. And Chair, those further appointments, if anything, they would confirm the understanding that we were certainly appointed for a period of longer than 1 year.
Because you see, if reliance is placed on those annual letters, I would imagine that what would happen is that somebody would say, Well, we have been appointed 1 year at a time. Every year we get appointed. So the duration of our appointment is no longer than 1 year at any time. In other words, this year, our obligation is for this year. Whether we will have any obligations, any job in regard to SAA next year, we don't know. We will know when we have been given another letter. Would you go along with that?
I do understand you, Chair.
Okay, thank you.
And then just to return to the BAC committee record, I understand you to say it might have been missed because it wasn't in a sample. You don't know that as a fact, do you?
Chair, hence I indicated because this predates my involvement, it's difficult for me to respond to a question like that, Chair. Whatever I say would amount to speculation, Chair, which I don't believe it's fair on the person.
If you'd seen a minute like this, would you have been concerned that the appointment of PwC and Nkonki since the 2012 financial year was irregular?
If I saw this, I would be concerned. That's correct, Chair.
And would you accept that the appointments for the 2013 to 2016 financial year then would have constituted irregular expenditure under the PFMA?
Chair, based on the understanding that Ms. Homer has, that would be the case. But certainly, Chair, based on the understanding that I had, because the understanding was that it was a period of 5 years, I wouldn't have thought so, Chair.
But with your knowledge now, you accept that it did constitute irregular expenditure?
Chair, without seeing how this matter was finalized, because there's an issue raised here, I'm not too sure that one is able to respond to that. Secondly, Chair, also appreciating that where there's irregular expenditure, there is an opportunity for the entity to regularize it. And having not seen what they would have done to correct the matter, I'm not too sure I could respond to that, Chair.
Let me, in fairness, break it down. We've accepted in your evidence that the procuring of audit services is procurement that must comply with the PFMA for an entity like SAA, correct?
That's correct.
We know that they tended to provide, to obtain audit services for the 2012 financial year, correct?
That is correct.
We know that they did not tender to receive audit services for the years 2013 to 2016, correct?
Chair, there was no official tender process run by SAA.
Yes. And we know that procurement not in conformity with the PFMA constitutes irregular expenditure, correct?
That is correct.
So then I put it to you again, the appointment of PwC and Nkonki for the 2013 to 2016 financial years therefore constituted irregular expenditure, correct?
Chair, that would be correct to the extent that there was no process put in place to regularize it.
And do you know what PwC and Nkonki were paid for those 4 years of audit work that constituted irregular expenditure?
Chair, I don't have the amount at the top of my head, but it is included in the picture.
I will assist you if you're willing to trust my calculation abilities, Mr. Motibe, because I've taken each of the payments that we received from SAA for the 2013 to 2016 years, for each of Nkonki and PwC, and I've added them up, and the total I got to was 69,760,888 rand. Does that sound right?
Mr. Motibe, I would just warn you not to be very trusting of a lawyer's calculation.
Mr. Motibe, let's do it this way. Over the lunch break, I'll direct you to Ms. Olitsky's affidavit. As I tally them up, it's 69,760,888 rand.
If you say so, ma'am.
Thank you. And if over the break, let me just give you the reference so you can go there. Her affidavit is in DD 19C at page 49. If over the break you establish that I've made a calculation error, you can let us know after 2 o'clock. Are you comfortable with that?
Chair, I'm comfortable.
She probably got it right.
Well, I'm not always sure with calculations,
You must check.
it's in the order of 69 million, I suggest.
I will trust the chair.
Yeah, okay.
So that 69 million of irregular expenditure didn't get disclosed in the financial statements for the years 2013 to 2016, did it?
Chair, at this stage, and based on understanding, because we did not believe it to be irregular, it had not been disclosed.
Thank you. Mr. Motibe, I'd like to move.
I'm sorry. If PwC believed that it had been awarded a contract for 5 years, it had been appointed for 5 years, that the request for proposals told competitors and others in the public that whoever was going to be appointed would be appointed for 1 year. And if PwC as they continued every year to do this work, that they were performing work in circumstances where there was irregularity, because the request for proposals and the letter of appointment said 1 year. It didn't say 5 years, and yet they were continuing every year.
Chair, as I indicate, much as the letter said 1 year, the understanding would have been that it was a longer period. We have never been in an environment where we saw an appointment of auditors being done for 1 year only. So
I understand. I understand that. I'm sorry to interrupt you. I understand that. But my question is, you ought, as PwC, I would imagine, you ought to have paid some attention to whether you were performing these duties under a regular arrangement, under a lawful appointment. And a lawful appointment, you would have known, must have been that if the invitation, the request for proposals said it's for a certain period, and you competed with your competitors, with other people, and you competed for 1 period, for a period of 1 year, when you get to continue and do the work beyond that period, it must be irregular. Because your competitors, call them XYZ, who let us say, well, I don't know how many bidders there were, but let us say there were 2 bidders, and you succeeded. XYZ was another bidder, they didn't succeed. So as far as they are concerned, you got a tender for 1 year. Now they hear that 2 years later you are still there, 3 years later you are still there, 4 years later you are still there, but they've been watching for any new tenders issued by or requests for proposals issued by SAA, they must feel aggrieved to say, but these people were appointed for 1 year. Why are they continuing? Why are we not given an opportunity? What's happening? And I'm suggesting that as PwC, that ought to have been a concern to you as PwC, because you knew that the letter of appointment said 1 year. You knew that the request for proposal said 1 year.
Chair, I would think that, Chair, as I explained my understanding and what we see in practice would have covered part of that, in that we have never seen any a company with this size, this complexity, put out a tender for only 1 year. If anything, Chair, I would think that we should have been able, which we did, Chair. We took comfort in the fact that the office of the AG gave concurrence, and I know that as part of the concurrence process, they do ask about inquire of the procurement process that has followed. Our appointment was also confirmed at the AGM, and at the AGM, Chair, all those who are charged with governance are there and able to raise objections or issues as appropriate. But, Chair, the fact that our appointment was also approved, or the concurrence did come from the office of the AG. I do think we were able to take comfort on that, Chair.
Let me ask this question. If PwC's genuine understanding was that when this letter of appointment said you are appointed for 1 year, 1 financial year, it actually didn't mean that. It meant 5 years because of all the reasons that you have given. Why would PwC not have said to SAA, why do you write 1 year? Why don't you write 5 years, even if it's subject to renewals every year based on whether you have done the job properly the previous financial year? Why would PwC not say, why are you giving us a letter of appointment that says 1 year? Because maybe we all know this is for 5 years. Because if PwC has accepted a letter that says 1 year, 1 financial year, but its understanding is that this is for 5 years, SAA would be entitled, would they not be, after 1 year, to say, we are requesting proposals for the following year, and you can't complain because you know that you are appointed for 1 year. So I just have this concern as to how do you accept an appointment on the basis of a letter that says 1 year, but you say your understanding as PwC is that this is for 5 years, but you don't point out to say, change this letter, because you and I know that is for 5 years, or we only put in a bid on the understanding that is for 5 years. So your letter is, we are not prepared to do this job if you are restricting us to 1 year. We will pull out if you insist on 1 year. Why didn't PwC say that?
Chair, it would be a bit difficult for me to respond to, as I was not part of that initial process, Chair. I don't have a responsibility for that, Chair.
Sorry, your voice went down again.
Oh, sorry, Chair. Apologies.
Yeah.
I was saying, Chair, I was not part of the process back then, Chair. So I'm not able to, I don't know I don't have a
Yes.
response for that, Chair. I cannot
Yes.
respond to that question, Chair.
Yes.
I might have to go back and just understand
Yes. Yes.
why that did not happen, Chair.
Yes. Would you accept it as an expected, a natural response that one would have expected from PwC to the letter of appointment if their understanding was this is for 5 years? Would you accept that what I'm suggesting would be the response that one would expect from PwC to say, well, you've got it wrong on your appointment letter because our understanding is that we are here for 5 years. And quite frankly, if you say 1 year, we think it's financially, commercially not viable, we will pull out.
I do understand where the chair is
Yes.
coming from.
Okay.
Ms. Mothibe, you made reference to the Auditor General's oversight. Are you aware that the Auditor General took the view during the term of your appointment that the appointment of auditors did have to follow a procurement process?
Yes, I'm aware that it does follow a procurement process.
And do you recall what the Board of SAA's reaction to that was when they received that advice from the Auditor General?
I don't recall, Chair. I think you are talking about the. Can you maybe just remind me which year you are talking about, Chair?
Of course, in 2015, the Board of SAA wanted to move all the auditing services to Nkonki, and they received advice from the Auditor General that they could not do that without following a tender process. Do you know what the Board's response to that advice from the Auditor General was?
Not off the top of my head, Chair.
We'll go to the minute later because it was one of the minutes that I assume you would have been looking at in your audit procedures. But just to jump ahead, the Board of SAA recorded that it was strange, quote, that the Auditor General required it to go out to tender for its audit services. Do you share that view of the SAA board, that it was strange that it should be required to procure these services in accordance with the PFMA?
I do not agree with the view of the board now.
Thank you.
I'm sorry. I don't know if it's me alone. I'm freezing.
I have never been so cold in my whole life, Chair, so it is not just you. It is terribly cold.
How far away from lunch? 30 minutes.
Chair, I don't have a difficulty, if it would be convenient, with us taking an early break now and we try and do something in the next hour and return at 1:30, if that would improve things, I don't know.
Well, I think maybe we should, if we can, just persevere for the next 30 minutes.
Yes.
And then during lunchtime, hopefully somebody can do something. I think some time back, they said they could do something to make the room warm. So hopefully after lunch, but I think it does take quite some time, but I think let's persevere if we can.
With
for the next 30
fortitude,
minutes.
we'll do it,
Yes,
Chair, and
yes,
we'll make inquiries over the break if there's
yes,
something that can be
yes,
done.
Yes, and yeah, I think if you have an overcoat or anything,
Yes.
feel free to
You may see me return with the
Yeah.
overcoat, indeed. Thank you.
Yes.
Ms. Mothibe, I want to move from the topic of your appointment to the association that PwC had with Kwinana and Associates. I suspect somebody might have been listening. Chair, it seems we might have been spared the freezing air that is circulating in the room, but let's see how it goes. Right, Ms. Mothibe, for this purpose, if we can go in your first statement, which is in DD 19A, and if you can pick it up at page 12, please.
I have the page, Chair.
Did you say 12? Or
12,
10?
yes, 12.
Okay.
Thank you, Chair. Now there on that page you have a heading, Payments Made by Nkonki. Oh, apologies. Sorry. Oh, well, I think your heading is just slightly inaccurate. You say there, payments made by Nkonki to Kwinana and Associates. I've only picked that up now because what you deal with here is actually payments made by PwC to Kwinana and Associates. Is that right?
That is right.
Okay, so that's an error that neither you nor I picked up before. But what you're dealing with in this section of your statement, as I understand it, is well, let's give the background. The Commission picked up a series of payments to Kwinana and Associates, the auditing firm of Ms. Yake Kwinana, who was a non-executive member of the board of SAA and the chair of the Audit and Risk Committee. And we required of you in producing the statement that you address those payments. And can I take it that that's what you do from paragraph 46 on that page?
That is correct, Chair.
And then just to speed things up a bit, I just want to be sure that we're on the same page about the facts. As I understand it, there were 3 potential tenders that you bid together with Kwinana and Associates for. Is that right?
That is correct.
And as I have it, the first of those occurred in late 2014, early 2015, and you submitted a bid with her firm to the Eastern Cape Department of Education to provide internal audit services. Is that correct?
That is correct, Chair.
And that bid was unsuccessful, correct?
That is correct, Chair.
Then there was a second one. You describe it as being in late 2014, and that related to audit work done at PRASA. Is that correct?
Chair, that is correct, but Chair, just a correction, it was not audit work. Chair.
Right.
It was not audit work.
That I didn't have correct. So it was other work, professional services.
It was professional, just to inform the Commission, it was work performed by one of our former companies that we have since disposed of, Combined Systems, and it was in the area of asset verification.
Right. Just give me a moment on that, if you don't mind. Sorry, so I'm just trying to understand. It was it was services that Kwinana and Associates rendered together with PricewaterhouseCoopers. Is that right?
That is correct.
Thank you. But not audit work.
Chair, it does not audit work.
Thank you. Thank you. And then the third bid was submitted in October of 2015 to provide consulting services to the Department of Military Veterans. Is that correct?
That is correct, Chair.
And that was also unsuccessful.
That is correct, Chair.
So just to summarize, 3 bids you put in jointly, 2 of them unsuccessful, 1 of them successful, correct?
That is correct, Chair.
And the total amount paid to Kwinana and Associates on the successful bid, can you tell us what that was?
The figure, Chair, is 6,187,799 rands and 90 cents.
Now, as I understand your statement, Mr. Motibe, PwC has a whole internal policy that is in place in order to guard against these joint business relationships with people associated with their audit clients compromising their independence. Is that right?
That is correct.
And you take us through in your statement what those policies are. Is that right?
Yes, I do indicate it in my statement, Chair. That's correct.
And can you also confirm whether my understanding is correct, that PwC permits these joint business relationships when their materiality and significance is not of an order to compromise independence?
That is the correct statement, Chair.
And because of that policy and because of the impact for independence that these sorts of associations can have, as I understand your statement, PwC took steps to establish from Kwinana and Associates whether this work for that audit firm was material or significant. Is that right?
Yes, Chair. We have as part of our risk management, Chair, we have an office that looks after joint business relationships. And before we enter into such relationships, Chair, we confirm whether or not first of all, Chair, we do integrity checks on the persons involved. Once we are comfortable, Chair, we then also confirm that the amounts involved, whether or not they're material to either PwC or to that entity, because if they're material, Chair, they may have the effect of impairing one of the parties' independence, Chair.
And what threshold does that internal policy set for materiality?
Chair, in terms of the IESBA code, which is an intentional code, Chair, that we follow, and PwC code, Chair, the threshold that has been set is at 5% of total revenues. So the revenues from these contracts could never exceed 5% of PwC's own revenue. In terms of our policy, and we made similar inquiries of Ms. Kwinana in that regard, as to whether or not the said revenues would exceed those thresholds.
Yes. And as I understand your statement, PwC then did engage with Kwinana and Associates in order to establish whether the thresholds were met. Is that right?
That is correct, Chair.
And it did so at the end of 2014. Let's just go there. You'll find the particular email containing that query in DD19C at page 132.
I've got the Chair.
Thank you. These are copies of emails that you provided to the Commission. Is that correct?
That is correct, Chair.
And it was after we followed up, having read your statement. They weren't originally attached to the statement. Is that correct?
Chair, it was after on the original statement, the Commission had not included inquiries as to the payments that were made to Ms. Kwinana. I think that came after our first interaction. So
Yes.
in response to that, we then provided.
Yes. So your statement referred to you checking, and then we called for the emails disclosing that checking. Is that correct?
That is correct, yes.
I want to start at the first email in time, which appears at page 132, as we had it. It's the bottom email in the second half of the page from a person named Nikki Wayne. Who is that?
Nikki Wayne was a manager in our marketing and business development department, Chair.
And if we pick up the last paragraph in that email, you'll see that Ms. Wayne says, please determine if the JBR, I understand that to stand for Joint Business Relationship, is that correct?
That is correct.
With PwC will be material for Kwinana if the fees for Kwinana for the current JRB relationship with PwC exceeds 10% of their annual turnover. The relationship will be deemed material for them. Do you see that?
I see that paragraph, Chair.
Why is this referring to 10% rather than the 5% required under the PwC policy?
The 10%, if my memory serves me right, was a threshold that was shared to us by Ms. Kwinana in terms of how she runs the business on her side.
So you apply a 5% risk, but she communicated to you she applies a 10% risk. Is that right?
Chair, from my reading of this, that is the case, Chair.
But just hang on. Were there interactions with Ms. Kwinana before this email went out?
Chair, the interactions with Ms. Kwinana would have been by the proposed engagement leader on the assignment, who then would have made inquiries to me as to whether or not I'm aware of first of all, there's a relationship between Ms. Kwinana and PwC, and whether or not there are any issues regarding independence.
Well, let's just unpack that a bit. Are you aware of, or did you yourself have, interactions with Ms. Kwinana before this email was sent, in which she disclosed to you 10% is her risk threshold?
Chair, the communication in terms of determining independence, anything in that space is run by a separate risk management department. I did not have any, I didn't have communications with Ms. Kwinana in that regard. There's an independent, separate office that runs that process.
So how did you come to know the point you made a moment ago, that Ms. Kwinana's risk threshold was 10%?
Chair, in preparing for this, there were certainly inquiries with persons that were involved to understand where we were.
So somebody at PwC who was part of that team has told you before today that the reason why they asked for 10% was because that was Ms. Kwinana's threshold. Is that correct?
From the reading of the mess, yes, that is correct, Chair.
That is correct. Why does PwC apply Kwinana's threshold and not its own threshold?
Chair, the thresholds, there's different thresholds that apply, that we apply. For Ms. Kwinana, she has got her own code. The PwC code goes further than what the international standards require, Chair. So we made inquiries. We got an understanding of what they apply and whether or not the proposed fees would have been breaching the threshold.
But why would PwC, who's concerned to ensure its own independence, accept the threshold of the partner? Why doesn't it apply its own threshold?
Chair, this work is carried out by the Risk Management Department. I'm not privy to the details of what goes on into that process. I have to take comfort on the work that is performed by the back office.
Is it permissible under the PwC policy to simply apply the threshold of the partner?
Chair, it is permissible. If it was not permissible, we would not have proceeded with the joint business relationship.
Can you direct me to where in the policy it says that's permissible?
Chair, I'll have to go and maybe during the break, Chair, we'll have to look at where we can deal with that, Chair.
Because let me tell you, I have not found it in the portions of the policy that you've provided to the Commission. What if the audit, the potential business partner's threshold was 50%? Would you apply it?
Chair, I would have to take guidance on that. We would have obviously the Risk Management Department has got guidelines that they follow, and based on the guidelines, they would then have made a recommendation, and would have followed that recommendation, Chair.
Are you aware of what Kwinana and Associates' response was to that inquiry made by Ms. Wayne in December of 2014?
Chair, if my memory serves me right, they confirmed that the revenues would be below the 10% threshold.
Well, let's go to it in particular. You'll find it in DD 19C at page 131. It's at the bottom of that page, the relevant email. It's from somebody named Lumka Goniwe. Do you know Ms. Goniwe?
No, I do not know Ms. Goniwe.
So you do not know that she's related to Ms. Kwinana?
No, I'm not aware of that.
And you'll see the subject there is Department of Education Internal Audit, Kwinana JBR query. Do you see that?
Yes.
So this related to that first tender that you bid together with Kwinana and Associates for, is that right?
Yes, that is right, yes.
And that was the one that was unsuccessful, correct?
This one was unsuccessful, yes, Chair.
Yes. And what Ms. Goniwe records there I'll just read it into the record for convenience, is good morning, Nishan. We've calculated our fees to be in the region of 4.1 million, excluding VAT. I confirm that Kwinana and Associates turnover is more than 50 million. The BEE certificate reflects Kwinana and Associates before the demerger with Kwinana Equifin. I also confirm that Yake is a non-executive director of SAA. I hope you find this in order. Do you see that?
I see that, Chair.
And can we take it that PwC did find this in order because it proceeded to bid with Kwinana and Associates?
As I do indicate, Chair, the work would have been performed by the risk management department that looks after joint business relationships, Chair. And one, we have to take comfort on the work that was performed by that area.
Do you always just take the say-so of the prospective joint business partner when you embark on these relationships?
I'm not too sure that I understand the question, Chair.
Thank you. Let me be clearer. I understand the process you followed simply to involve this email exchange. There was the request, tell us if it's over 10%. There was a response, it's not over 10% because our annual turnover is 50 million. Do you not probe any further than that? Do you just take what they say in the email as sufficient?
Chair, as I said, the process is run by a back office that looks after risk management. It's probably also important to add, Chair. Ms. Kwinana is a chartered accountant. She is a registered auditor. There is a code of ethics that guides how we deal with how we behave, Chair. And with her being a registered member of the bar, belonging to the same profession, I take it that she subscribes to the code and that there's no reason to doubt the integrity when the providers with us.
It was the independence of your audit, though, that was potentially to be compromised by this association. Did you make inquiries about this process at all at the time?
I did not make inquiries about the process. As I indicate, there is a back office that runs this process, Chair, and one takes comfort in the inquiries that they make.
And
I wasn't sure, Ms. Hofmeyer, whether the you in your question related to him or to PwC.
Oh, right. Well, I should be clear. It was PwC, but by this point in time, as I understand it, you were the audit partner. You'd taken over from your predecessor. We're now in late 2014. Is that right?
That is correct.
Thank you. So both, I guess then, Chair, you in the PwC broader sense, but you in particular, Mr. Motibe. But you've indicated you did not make inquiries. Can I ask, and I take your point about the code of ethics, is it not customary just to ask the joint business partner for their previous year's financials so that you can just have an extra check on whether what they're telling you about the percentage of turnover is accurate?
Chair, I'm not part of that process, the GBR process, so I cannot comment on that question.
Do you think it would be a good step to take?
It does make sense, Chair.
What I want to put to you, Mr. Motibe, and it's not facts that you would have had at the time, but if you were to learn that Kwinana and Associates' annual turnover for the relevant year, that's the year ending February 2015, was only 10,567,581 rand, would you then be concerned about entering into a joint business relationship with the firm who was going to earn 4.1 million rand out of that relationship?
Chair, I would be concerned.
It would constitute about 38% on my calculation of Kwinana and Associates' actual annual revenue for that year, turnover for that year. Again, you can do the maths over lunch if you want to check me. But Mr. Motibe, let's move on. So you take what Ms. Lumka Goniwe is saying in response. She says 4.1 million is less than 10% because their annual turnover is 50 million, and you proceed. Is that correct?
Chair, PwC ran the process through its JBR office. We were provided with information that we had requested, and we had no reason to doubt the integrity of the information as it was provided to us.
I understand that, Mr. Motibe. That was inquiries made in relation to the Department of Education bid, which we've confirmed in your evidence was unsuccessful. Then you bid with Kwinana and Associates on the PRASA bid, is that correct?
Chair, on the PRASA bid, as I indicated earlier, it was not PwC on the audit side. It was a subsidiary of ours that did the proposal. In that instance, Chair, Combined Systems, the company involved, did not follow due process. They did not make inquiries as required and put the joint business relationship through the necessary process. This information only came to my attention, in fact, when one started preparing for the commission.
Why didn't you say that in your statement then? That these processes were not followed in relation to the PRASA bid?
Maybe let's start with whether he accepts that he didn't say it.
Mr. Motibe, do you accept that when you dealt with this from page 12 of your statement in DD 19C, you did not identify here that the processes had not been followed in relation to the PRASA bid?
That is the case.
That is
Chair.
the case.
Yes.
But today you concede that the processes were not followed for the PRASA bid. Is that correct?
That is correct, Chair.
So PwC, sorry, and I just want to get clear because I had to hesitate earlier. You drew this distinction between PwC and some other company, but then I clarified with you that this was PwC who entered into the joint business relationship with Kwinana and Associates for the PRASA bid. I thought you said yes.
I think, as the Chair, Combined Systems was a wholly owned subsidiary of PwC. Chair, they were required to follow due process. After we made a submission, we obviously, Chair, proceeded to get an understanding with all further details, and we have confirmed that they did not follow due process. They entered into the joint business arrangement, but they are wholly owned by PwC, and they were providing asset verification work at PRASA.
And PwC paid Kwinana and Associates invoices, didn't it, for this work?
The arrangement, Chair, as it works, is that even with our subsidiaries, PRASA required payment or the invoices to come from one entity only, even though we are a joint business relationship. So it was, and because we own Combined Systems, the invoices would have come from PwC to PRASA, and immediately when we got remunerated for the work performed, we obviously, Chair, had to remit to Kwinana and Associates their proportionate share of the fees based on the amount of work they would have performed on the assignment.
So if we go to page 12, paragraph 50.3, you state there, in late 2014 and in the period up to 30 January 2015, PwC, with Kwinana as JBR partner, rendered professional services to the Passenger Rail Agency of South Africa. Do you see that?
That is correct, Chair.
Thank you. And that is a correct statement, is it?
As I indicated, Chair, it was Combined Systems who entered into the joint business relationship. Combined Systems being PwC at the time.
Who submitted the bid, PwC or Combined Systems?
Chair, I don't have access to the documentation, so it'll be difficult for me to respond to that question, Chair.
Can I assist you? Because your evidence earlier was the PRASA wanted to be dealing with one entity, as I understood it. Is that correct?
That's correct.
That entity was PwC, correct?
My understanding was that when you said to submit the bid, I'm looking at the original, the actual documentation, Chair. Hence my response. I don't know what the document was on the documentation. Therefore, I cannot respond because I was not part of that process, Chair.
Does PwC take responsibility for its wholly owned subsidiary not complying with its requisite procedures?
That should be the case, Chair.
Thank you. And the consequence of that is that PwC entered into a joint business relationship with Kwinana and Associates for the PRASA bid in circumstances where it did not confirm whether that joint business relationship breached its own policy. Is that correct?
Yes, Combined Systems entered into the joint venture or the JBR without following due process.
And if Kwinana and Associates earned 6.1 million from that, and you were to learn that its annual turnover for the it would have been 2016 financial year was in the order of 21 million, do you accept my maths if I say that that was constituting more than a quarter of the annual turnover of Kwinana and Associates?
Your maths is correct. Yeah.
Thank you. And had PwC known that, it would not have entered into the relationship because it might have compromised its independence, correct?
That will be correct, subject to the work that we have been performed by the JBR office, Chair.
Thank you. Chair, it seems an appropriate time to end. We've hit 1 o'clock. Maybe warmth can be generated for the room in the break.
Yes, I hope so. I hear some noise back. I hope that it's for warming the place up and not taking us back to where we were before. So I'm sure somebody will take care of that. We are going to take the lunch adjournment and we'll resume at 2. We adjourn.
All rise.
both Mr. Motibe and Ms. Masasa, but you will see from the affidavit they generally agree with the position taken by each other, and in that respect it is not contentious in any way, and so we would seek to admit it simply provisionally. If it becomes contentious at any point, as we've done previously, decisions may be taken about the need to call Ms. Masasa. But it is very similar to the position taken by Mr. Motibe today. Chair, I won't need to go there unless it becomes necessary. I'll simply summarize. What you would have seen, Mr. Motibe, if you considered it, is that the Commission also probed certain payments that it could determine had been made by Nkonki Inc. to Kwinana and Associates, and those payments spanned the period September 2015, August 2015 to July 2017. And within that period, there was 850,068 rand that Nkonki paid to Kwinana and Associates. And just for the record, Chair and Mr. Motibe, Ms. Masasa explains that related to work at Transnet and Eskom that Nkonki had done with Kwinana and Associates. I want to put those payments to one side because the one that I want your comment on is a curious payment. It's a payment that Nkonki made to Kwinana and Associates on the 28th of August 2015. And Ms. Masasa explains that payment in her affidavit, and if we can just go to it, you'll find it in DD19C, the file we've been in at page 42.
I've got the paragraph, Chair.
You've got it, excellent. Now at 42, paragraph 63.3, you'll see there that Ms. Masasa deals with, I said it was a payment of 300,000 that I was particularly interested in, but there were two that she's addressing in this paragraph, 63.3, because she says there are two payments totaling 312,500 rand were made in relation to supplier development, right? And she goes on and she says, she's been advised by Ms. Zilwa. Now, let me just explain. Earlier in her affidavit, Ms. Masasa indicates that Ms. Zilwa was the CEO of Nkonki at the time. Ms. Masasa had no knowledge of these payments, and so in an effort to assist the Commission, she went and established the facts from Ms. Zilwa. Chair, just to close that gap, we didn't then go and get an affidavit from Ms. Zilwa. She confirms what Ms. Masasa records here. So there's no issue there. But let's see what the account of these payments is that's given. Ms. Masasa says she was advised by Ms. Zilwa that these payments were made by Nkonki for the benefit of the Abasa Practitioners Fund. According to its website, the APF, as she abbreviates it, was established in 1985 to promote the professional interests of black persons engaged in the accounting profession. The APF promotes the interests of various small black-owned audit firms. Ms. Zilwa has advised me that the payment for 12,500 rand on the 26th of March 2015 was a subscription fee Nkonki paid for the benefit of APF, and the payment of 300,000 rand on the 28th of August 2015 was in relation to a sponsorship fee paid by Nkonki for the benefit of the APF. I'm further advised by Ms. Zilwa that the APF bank account was, and she puts in quotations, not functional at the time, and that the APF member firms, therefore, again in quotes, felt it was convenient at the time to deposit funds meant for the APF into the bank account of Kwinana and Associates. So that's the explanation that Ms. Masasa was able to obtain from Ms. Zilwa, the former CEO of Nkonki. Now, Mr. Motibe, can you help me? Do you know of the Abasa Practitioners Fund at all?
Chair, I'm aware of the existence of the Abasa Practitioners, I think it was the forum, which was formed years ago, where a number of black audit firms came together to create capacity so that they can propose for big assignments, audit assignments. And in fact, I think years ago, they became a beneficiary of I think it was a Transnet audit proposal. So certainly the name Abasa Practitioners Fund or Forum does ring a bell.
But are you saying what you know of is Abasa Practitioners Forum? You are not sure of Abasa Practitioners Fund?
Yes,
but
I'm not too
maybe
sure how
there
they
is.
relate to each other, but
Yeah.
I think that principle, I am aware of that, Chair. Of that.
Yeah, so you know about the forum, but whether there is also a fund, you don't know, or you do know.
Chair, I'm aware of the forum, about the fund.
Yes.
I was not aware of that, Chair.
Yes.
As you appreciate, Chair, it was an organization for black audit firms.
Yeah.
And because I was then an employee of
Yeah.
back then PwC, I would not have been privy
Yeah.
to that. So whatever comes below the forum, Chair,
Yes. Okay.
Well, pursuant to receiving this affidavit from Ms. Masasa, the Commission did further investigations, and it in fact engaged a Mr. Ashley Walter Dickon, who, when he deposed his affidavit, Chair, this is another affidavit that's been obtained, again, simply to give facts about Abasa and APF. Again, I propose that we admit it provisionally. There's nothing contentious in it, and I do understand Mr. Motibe's previously been provided with a copy. This is a affidavit
Well,
that...
I'm sorry, we said, by the way, that those documents that fall presently under C,
Yes.
we'll leave them as they are.
And
but
we're going
later
to
on- Yes, okay.
Absolutely. So you will, in due course, Chair, receive a list,
Yes,
properly itemized what the documents are. And so amongst them will be Mr. Dickens' affidavit.
Yeah.
We'll properly identify it, but for present purposes, just to tell you where you would find it, it's
Yes.
in DD 19B, D, which is the second file, the one we
Yeah.
haven't been working in yet, and it commences at page 489. It's headed...
489.
489. Chair,
Okay.
you'll see it's headed replying affidavit, but that is because I think Mr. Dickon understood himself to be replying to the questions from the Commission. So you mustn't be confused that it's preceded by other affidavits relevant. It's simply that he offers his reply to the Commission's inquiries.
Well, on 489, I don't have a replying affidavit. I've got, and I don't have the name.
Oh,
I've got I, comma, blank space, full name, solemnly declare, it's not signed.
No,
Goes to the next page.
that's a different page to the 489 I'm looking at. So maybe there's been a numbering error.
I'm looking at the
The second file.
legislation reference bundle.
Oh, no, sorry, then you're in the wrong one. I think your registrar might have put the file you need just on the side here.
Okay.
It's the D, what you should be looking for is DD 19B on the spine, but we have numbered this and entered it into the record as DD 19D. And if you open up 489 there, Chair, you should have a affidavit. Mr. Motibe, do you have it?
Yes.
Thank you.
Well, looks like there are challenges.
Oh, no.
Where I'm supposed to have page 489, I have got page 531. There is a jump from 488 to 531, and there is nothing.
Chair, it may be that we've got an additional copy that my learned friend can just assist me with. Chair, that ought to have been placed in your file this morning. I do apologize. The other new files that were brought up had it. So that is 489 now to be inserted in your file. Seems Mr. Motibe's updates were done, but
I think, Chair, maybe some of this would have come, should have been in your file, because I see
Have you got the
it's been
duplication?
duplicated in my file.
Oh, yeah, okay, somebody.
oh, maybe you have the chair's copy. Oh,
Well, maybe
duplicated,
somebody
so-
thought the witness must have two.
yes, indeed. We want to be doubly focused on it. So thank you. If you'll just put it to the side, Mr. Motibe, we'll collect it later. Thank you very much. At least we've identified where the rogue extra copy went.
So as things present stand, you have now given me pages 489 to 430. So that seems to complete the pages that were
Yes,
missing.
exactly,
Yeah, okay.
exactly, Chair.
Okay. All right. Thank
So as
you.
I was describing, it's entitled Between the Tram Lines as a replying affidavit, but that shouldn't confuse the lawyers in the room. It's simply, I take it to be Mr. Dickens' way of indicating he's responding to the questions that he received from the Commission. And I propose simply to summarize what Mr. Dickens says here. Mr. Dickens is a member and interim president of the Association for the Advancement of Black Accountants of South Africa, that is ABASA, the entity that we have been talking about. And what the Commission was interested in establishing from Mr. Dickens was, can he help us with this relationship that Ms. Zilwa describes was in place? That there was this APF, the fund, the ABASA Practitioners Fund, that at some point in 2015 it didn't have a bank account, and so members of the auditing profession were paying to Kwinana and Associates what was really intended for the ABASA Practitioners Fund. We just wanted to get to the bottom of what he could tell us about those facts. And Mr. Motibe, what he tells us, and I'm going to summarize now, is that those facts are false. That there was no ABASA Practitioners Fund operational in August of 2015, when Konki allegedly paid 300,000 Rand to Kwinana and Associates bank account for its benefit. He attaches to his affidavit reams of SIPC documents that he gets to support this, the upshot of which is that the ABASA Practitioners Fund was deregistered in 2011, 4 years before the payment was made. Right. The next thing that is mysterious about the payment, and Mr. Motibe, I will have a question, I promise, after I've just given you this background, is that 5 days after it was paid to Kwinana and Associates bank account, allegedly for the benefit of a fund that didn't exist, it was paid out of Kwinana and Associates bank account into the personal bank account of Ms. Yake Kwinana. Ms. Motibe, before today, did you know those facts?
Chair, this is the first time I hear about these matters. This is news to me.
Well, let's just, for completeness' sake, take you to those bank statements, because we don't want to leave any stone unturned, and we want to be looking at the documents when I give you the background to the Commission's investigations. You'll find the bank statements that reflect this in the same bundle you've been working in, DD19D, and if you go right to the back and pick up page 622, you'll find them.
Chair, I do have sight of them.
And I'd like to take you to the relevant entries. Page 622, you'll see at the top the account name is Kwinana and Associates Gauteng. GAU is short for Gauteng Inc. And you'll see there are 3 dates there reflected on the left-hand side. The first is 2015-08-28. That is an ABSA cash FOC, I don't know what that's standing for, CT ad hoc TRA, I think that's transaction. And that's an amount of 100,000 rand in the top line you can see going into the account. And then the one that we're interested in, the payment from Nkonki Inc. to Kwinana and Associates, is the next entry, 2015-0828. It says internet payment credit, and then you see 300,000 rand there. Do you see that, Mr. Motibe?
I do see that, Chair.
So that's how the Commission was able to identify 300,000 rand being paid by Nkonki to Kwinana and Associates on the 28th of August 2015. And then you see at page 6, sorry, let me just get this right. Right. Then you have to go over to the next page, 623, which is the next page of the Kwinana and Associates account. And what you'll see there in the last line is an entry on 2015-0902. Do you see that? The last line is a 2015-0902 entry, and you'll see there what gets paid out of the account is 630,000 rand. Can you see that?
I see that, Chair.
It's important, Chair, just to go back and say, what you are looking at on these statements are transactions in the Kwinana and Associates bank account from the 28th of August to the 2nd of September. It's a period of 5 days, right? And what we've seen is 300,000 rand comes in on the 28th of August. There's 100,000 before that, there are a few subsequent payments after that, and then in a sense the whole account gets debited out, because on the 2nd of September 2015, you'll see that 630,000 goes out, which leaves a balance in the account of 2,795 rand. You see that? So we remain confident in our conclusion that the 300 that came in on the 28th goes out with the 630,000 on the 2nd. And then the question is, to whom does the 630,000 payment, which includes the 300,000, go? And for that purpose, you go to the last page, which is page 624. And you'll see there, this is the account of Ms. Yakwe Kwinana, and you'll see on the 2nd of September 2015. Let me tell you how many lines down, 1, 2, 3, 4, 5, 6, 7. It's the 7th date entry on the left. You'll see next to it, it says iBank transfer settlement, and you'll see 630,000, confirming that that amount came into that account.
Is that the one written settlement?
Yes.
iBank transfer,
Yes.
and then is it the
630.
account number that's given immediately under transfer?
Correct.
Yes. Okay, yes.
So that's how we track the movement of the money, Chair. Just to explain the facts as I was detailing them for Mr. Motibe. And what that tells us is 28 August. Yes, Chair.
So if Ms. Zilwa and is it Ms. Masasa?
Indeed, Chair.
If their version is true, that this was money that they paid to, that was paid to Kwinana Associates and Associates Inc. for the benefit of Abasa practitioners, and if it is, if you are right indeed that in the conclusion that that's the money that goes out into Ms. Kwinana's personal account, then on the face of it, it appears that money that may have been intended for Abasa practitioners ends up in her personal account.
Yes.
If, of course, their version is not true, it was never money for Abasa practitioners, then that's also something else.
Indeed, that,
Yeah.
Chair, we can't probe further without Ms.
Yeah.
Zilwa attending. And
Yes,
again, I must
yes.
emphasize, Ms. Masasa says she has no personal knowledge of this.
Yes,
She relies on Ms. Zilwa,
Yes,
and Ms.
yes.
Zilwa tells her this, and then we go to Ms. Zilwa to get
Yes.
confirmation of these facts, and she
Yes,
provides it to the
yes,
commission.
yes.
So Ms. Zilwa's version is it went to Kwinana and Associates, but for the
Yes.
benefit of the fund.
Yes.
Right.
Yes.
Chair-
And I think you are right to emphasize that Ms. Musasa is not her version. It's
not.
what she says she was
Indeed.
told.
Indeed.
And she accepted what she was told.
And she can take it only that far,
Yes,
which
yeah.
is why we deemed it appropriate to go to Ms. Zilwa to get the confirmation from Ms. Zilwa. I'll take you there in a moment. So that is Ms. Zilwa's version to this commission on affidavit. I accept only on affidavit. This hasn't been probed with her. But what our further investigations tell us are really two things. The BASA Practitioners Fund did not exist in August of 2015, right? The second fact we uncover is that when we track the money in the account from the 28th of August to the 2nd of September, we can see it is paid out on the 2nd of September with other funds to Ms. Kwinana's personal account. But Chair, I absolutely accept the point. What we still don't know is whether Nkonki pays with the intention that it be paid, albeit to a fund that doesn't exist. Against their intention, it then gets paid to Ms. Kwinana. That we don't know, and that I certainly can't take further today. But the facts nonetheless are, it ended up in Ms. Kwinana's bank account. And the version before the commission today from Ms. Zilwa, albeit on affidavit, is that it was paid for the purposes of payment to a fund that didn't exist. So, Mr. Motibe, that takes me to the point at which I would like your assistance as the joint auditor of Nkonki. If you learnt, as you have today, that Nkonki made...
Of SAA.
Did I say of SA? Sorry.
It's
Joint
Nkonki.
audit partner of Nkonki for the audit of SAA. Indeed, Chair, I apologize. If you learned that Nkonki made a payment to the audit firm of the director of the board of SAA at a time that it was doing joint audit work with you, and it were to be established that that payment was gratuitous, and I say gratuitous in the sense that it's not for services rendered, it's just paid, and unrelated to any work performed, would you regard that as a compromise to Nkonki's independence in its audit work?
Chair, they would have certainly raised concerns from my side, and I would certainly would have raised it with our risk management department for advice on how to deal with the matter.
Would you have been increasingly concerned if you learned that the month before this payment was made, Ms. Kwinana motivated for Nkonki to receive the audit work from SAA for the next 5 years?
It would have certainly formed part of the input I would give to risk management, Chair.
I'm sorry, I think your
I'm
voice
saying,
has
Chair-
gone down again.
My shoulder, Chair. I don't remember, my elbow was on the... Chair, I would have, that would have definitely raised concern, and I would have certainly included that in the communication to my risk management department
Yes.
to seek advice.
Okay.
Let's go to what, Ms. Motibe, you did say in your statement about this topic of independence, right? Because you address it at page 14 of your statement, which you'll find in DD 19A. Page 14 contains the last paragraph of your statement. You say there in paragraph 55, I'm of the view that notwithstanding that the payments were made, these are the payments PwC made to Kwinana and Associates that you're referring to. You say, notwithstanding that the payments were made in relation to services unrelated to SAA, it was, in my view, incumbent upon Ms. Kwinana to declare the fees earned from PwC and Nkonki and recuse herself from any decision-making concerning their appointment as auditors of SAA and procurement of services from them. Do you see that?
I see the Chair.
Does that remain your view?
Chair, that remains my view.
And you then would accept that if Ms. Kwinana did not make those disclosures or recuse herself from the decision-making about whether to appoint PwC and Nkonki, that would give rise to a conflict of interest for her?
Chair, that would be the case.
Your voice went
Chair.
down even further.
Chair, that is correct. That would be the case.
Okay.
Were you aware that Ms. Kwinana never recused herself from the board meetings at which these decisions were taken?
I was not aware, Chair, and it is not something that we would have ordinarily checked, Chair, when we performed the audit.
But you did consider the minutes of board meetings, did you not?
We did consider the minutes of board meetings.
Would it not be an item you'd be looking at amongst those minutes when it deals with appointment of auditors?
Chair, the review of board minutes would be an item that would have been delegated to one of the team members. And we would typically be looking for areas like management or of controls, key contracts or the new contracts that are entered into. And Chair, this item, I think ordinarily would probably not have been something that they would have focused on.
But shouldn't they have? PwC was entering into joint business relationships with Ms. Kwinana's audit firm. That was enough to make PwC concerned about the impact of that relationship for independence. Shouldn't it also have been checking that Ms. Kwinana, the director of that firm, was not having anything to do with the decision-making to appoint PwC?
Chair, when we entered into the joint business relationships, we had already gone through a thorough process through our JBR process to ensure that the revenues earned from such contracts would not be material, and there's no risk that they would have impaired the independence of both parties. So already at that level, Chair, we are comfortable that the contract, whatever we had entered into, was below the thresholds. So, and that, Chair, gives one a great level of comfort. Secondly, Chair, typically when the requirement to disclose interest in contracts, it typically relates to contracts relating to work done within the entity. So, we had not entered into any contract with Ms. Kwinana relating to work relating to South African Airways or any of its subsidiaries for that matter, Chair.
Ms. Mothiba, I have to pick up on one aspect of your answer. You said PwC had gone through a thorough process to confirm that its independence was not compromised, correct?
That is, yes, the JBR process.
Yes, but your evidence before the break was that you readily accepted that in respect of the PRASA bid, no process whatever was followed.
No. Correction, Chair. I think what I'm saying, Chair, and I stand by it, is that, Chair, we've got a thorough process that we recommend within PwC, and that the expectation is that for every partner and for every person wishing to enter into a relationship with, in fact, with any of our existing clients, there is an independent process that they have to follow. If we are to enter into a joint business relationship, the PwC has a process designed to ensure that we identify and we confirm that there is no threat to our independence should that joint business relationship proceed. Chair, there was one contract that was entered into by Combined Systems, which did not go follow due process, Chair. And Chair, at this stage, I mean, the persons involved in that were dealt with, and in fact, Chair, we saw it fit to sell the business of Combined Systems because of the potential threats to independence that you have presented. So, Chair, we've got a thorough process. It is an expectation that every single employee or director of PricewaterhouseCoopers complies with that. And I'm comfortable that, Chair, everything that goes through that process, should the JBR office say, yes, you can continue, then, Chair, yes, we can take comfort in that process.
Ms. Motibe, in fairness to you, I must put it to you. If you don't follow the process that is prescribed, it cannot be described as having been thorough. Do you accept that?
Chair, we acknowledge that there was a failure by one of our subsidiaries to follow process, and that was appropriately dealt with. It does not mean, Chair, that the process that we have put in place does not work.
Ms. Motibe, I put it to you that that is precisely what it means.
Chair, what we had identified is that one of our companies did not follow due process, and that has been addressed. That matter was fully addressed, Chair.
Mr. Motibe, you came on to this point, and I had to ask you about it because in your answer to my question about the conflict of interest on the part of Ms. Kwinana, you went back to describe a thorough process, which I understood your previous evidence had conceded had not been thorough. But let's put that to one side for now. We're focusing on the conflict of interest that Ms. Kwinana has if she does not recuse herself. And I had put to you, would it not have been a requirement of your team, the PwC team, who knows it's entering into a joint business relationship with Kwinana and Associates, to satisfy herself that she is not making decisions to employ you each year for audit work? And I understood your answer to be, they don't need to do that because we've got a thorough process. Is that correct?
Chair, I said that in the review of minutes, there are certain items that we focus on. And this area was not one of the areas that we had focused on, because we were from my side, Chair, I was comfortable that there was process followed when it came to ascertain whether or not the joint business relationships that we entered into with Ms. Kwinana did not in any way impair our independence.
Well, the prior process that you talk about, that is meant, as I understand your evidence, to discover if there is conflict of interest. Is that what you called, is that the JPR, the process followed before you enter into a joint business relationship?
Yes, Chair. It is done through what we call a JBRI system, where the risk management team runs through the process to vet information that we have received from a potential partner and ourselves to ensure that we do not breach the thresholds, and that also the other factors that we consider to ensure that we maintain our independence at all times.
But would the people who would have been in charge of that process, would they have seen minutes of meetings at SAA at which Ms. Kwinana may have sat where she probably should not have sat?
Chair, those persons are not part of the audit team. They would not have access to those minutes because, as you appreciate, Chair, there's confidentiality around client information, and only those persons who are working on the client have access to that.
Yes, now, so the only people who could have a chance within PwC to pick up a point such as Ms. Kwinana said in a meeting which made this decision where she should not have said, the only people who could have picked that up would have been your team, isn't it? In other words, the team, the PwC team that was auditing SAA, whether when you had joined the team or not, but that's the team that should have picked that up, that had a chance to pick that up.
Chair, in the review of minutes, and when you typically review conflict of interest matters, it's, as I indicated, it is typically, it's on contracts relating to the company itself. So certainly to the extent that we had contracts with Mrs. Kwinana, or Ms. Kwinana, apologies, relating to work at SAA, those items would have obviously been required to have been documented, they would have been picked up. These contracts were outside the scope of the of that, Chair, and this item, Chair, I think it's important that this is more a fiduciary. What you have thought, it should have been a fiduciary requirement or duty on her to disclose, but there is no requirement within the Companies Act for her to make such disclosure. It is something that in our view, we thought it would be good, it would be best practice. I think that's what I was it would be best practice for her to make the disclosure, and I still do believe it should have been, Chair.
Ms. Hoffman.
Thank you, Chair. Ms. Mothibe, I'm not going to take those points further, other than to say, do you accept that an auditor must have not only independence of mind, but also independence in appearance?
That is certainly the case, Chair.
And would you accept that independence of appearance of an auditor may be compromised if the chair of the Audit and Risk Committee of the entity that they are auditing both votes to continue to employ the auditor, determine their fees each year, and is somebody who either herself personally is receiving payment from one of the auditors or her firm is receiving payment from one of the auditors?
Chair, I think it is also important to note that these joint business relationships are common in the South African environment, Chair, where professional services firms will work within each other in different areas. And so, there would be a requirement also due to transformation and transfer of skills requirements that we've had in our country. So us entering into joint business relationships with other professional services firms, Chair, it's not an anomaly. To the extent that, Chair, Ms. Hovey's question as to whether or not the independence would have been impaired, Chair, we took comfort in the process that we had followed. And, Chair, the appointment of auditors is not only done by one person, but it is done by a committee. No one individual would have excessive influence over the work that is performed by a committee. So, Chair, I do not believe that in this instance, Chair, our independence would have been impaired. I do take Ms. Hoffman's point that independence is not only independence, it's also independence in mind, Chair. And I do understand the issue that she's mentioning, Chair.
Ms. Mothibe, I'd like to move to the topic of reportable irregularities.
Maybe before you do that, maybe they should switch off this, I don't know, aircon, because it doesn't seem to me it makes
It's
much
difficult to call
difference.
it that because we're,
Instead, it interferes. Sometimes I can't hear Mr. Mutibe properly. I think just switch it off and let's see if we are going to get colder. Mr. Mutibe,
Chair?
I'm not sure if I understood your evidence correctly, where you were saying that, making the point that the decision to appoint auditors would have been made by a committee and no one person or one member of the committee would have excessive influence or something like that. You are not suggesting, are you, that somebody who is supposed to recuse himself or herself from the committee when it considers a certain matter doesn't have to recuse themselves because he or she doesn't make the decision alone?
No, Chair, I am not suggesting that, Chair.
Yeah, so what is the importance of the point you were making about that?
Chair, I think it was more to say the audit committee is made up of a number of persons. And it is a joint, if I can say, a joint decision, Chair.
But you wouldn't know whether, for example, for argument's sake, whether the decision was made in your favor because of one vote, and that vote happens to be Ms. Kwinana's vote.
I hear what you are saying, Chair.
If you are not supposed to sit, you should not sit, isn't it? You should not be part of the decision-making in regard to a certain matter if you are conflicted and you should not be sitting there.
Chair, that is correct. If you are conflicted, then you should be recusing yourself.
Yes, yes, okay. Or at least declare it so that it's known. There may be circumstances where you declare it, and if you declare it, nobody has an objection, you can continue, but this might not have been one of those situations. Okay, Ms. Hofmeyr, you may proceed.
thank you, Chair. Mr. Mutibe, could you help us with the following question? When is an auditor required to report a reportable irregularity?
Thank you. Chair, I will take you to pages DD 1908.
That, just for the record, Chair, is DD 19A, so it's in the first file, and it's page 8. Is that right, Mr. Mutibe?
That is correct, page 8. And Chair, that's where we confirm that the Audit Professions Act does place an obligation on an auditor to report to the regulator irregularities where he is satisfied or has reason to believe that they have been, they have occurred. Chair, we then also clarify on what we understand to be a reportable irregularity, which is an unlawful act or omission permitted by somebody in a senior management position, which has caused or is likely to cause material financial loss to the entity, which is fraudulent, amounting to theft, or which represents a breach of material breach of fiduciary duty. So, Chair, it is in that respect that there would be a requirement for one to report material irregularity or a reportable irregularity. And in fact, Chair, we had done so at South African Airways for the year ended 31 March 2014, the business of South African Airways was struggling, and we did not believe that they were a going concern. And management had not put in place a business rescue plan or of taking measures to give us comfort that the business would in fact be a going concern. At that stage also, government had turned down their request for a financial guarantee. And we then dispatched a letter to a regulator informing them of the challenges. Also that it could be seen that the business the directors are trading recklessly. And subsequent to us sending a letter through to the regulator, the Department then of Finance provided the required guarantees, which then allowed us 30 days after we have dispatched the letter, as required by the Act, to inform the regulator that the said reportable irregularity is no more continuing, Chair. So we do consider such, and where appropriate, we do report these irregularities to the regulator as required, Chair.
I was not aware of that before your testimony. Did that relate to the 2014 financial year?
That is correct, Chair. It was with regards to the 2014 financial year.
And just remind me, when did you take over the auditing function?
It was for the 2014 financial year. So it was in my first year of engagement.
And let us look at those requirements, because you have summarized them helpfully for me at page 8 of your statement. Just want to be sure for the rest of our discussion this afternoon that we're on the same page about your understanding of reportable irregularities. Is it correct that a reportable irregularity, on your understanding, requires there to be an unlawful act or omission committed by a person responsible for the management of the entity?
That is correct.
And then that unlawful act or omission must do one of 3 things. Is that correct?
That is correct, Chair.
It must either cause or be likely to cause a material financial loss to the entity. Is that correct? Or associated entities?
That is correct.
The second is that it is fraudulent or amounts to theft. Is that your understanding?
That is correct.
Or it represents a material breach of fiduciary duty. Is that correct?
That is correct.
And you also accept that you don't, as the auditor, have to be satisfied that these requirements are met. You simply have to have reason to believe that these requirements may be met.
That is correct, Chair. So there is an element of judgment that needs to be applied.
Yes, but it's a lower bar than being satisfied. Do you accept that?
That is correct, Chair.
Thank you. Now, the Commission, over what is now about 2 years, has received evidence related to a number of transactions taking place within SAA and its group of companies, which we have drawn to your attention before today and which you address in your statement. Is that correct, Mr. Motibe?
That is correct.
I'd like to focus on 2 of those transactions. The first is in relation to Air Chefs. And you'll recall that you were asked about that.
Yes, that is correct, Chair.
And just to find it in your statement, it's at page 9 of your statement, which is in Exhibit DD 19A at page 9.
That is correct, Chair.
And Chair, in the last third of that page, you'll see a heading against what is effectively paragraph 40A, which says 28 September 2015 decision by SAA board. That's the decision relating to Air Chefs, is it not, Mr. Motibe?
That is the paragraph, Chair.
Thank you. Now, the first thing I just want to understand, because I wasn't able to discern this perfectly from your statement, I want to know, when you were doing the audit work at SAA, did you, as a fact, consider this award when you were conducting the audit?
Chair, this award did come across what we call our audit areas, yes.
Okay.
We did have sight of these board minutes.
And you concluded that there was no reportable irregularity then?
Chair, when we looked at the facts that were presented to us, it did not trigger a reportable irregularity sensor, if I can put it like that, Chair.
Now, the evidence that the Commission has received, and again, Mr. Motibe, in fairness to you, I'm going to tell you about that evidence because I assume you're not somebody who watches the proceedings of the Commission every day. But I'm mindful of the fact that that might not be evidence of which you were aware at the time. Once I've done that, I'm going to take you to the documents that you would have been aware of at the time. But I want to give that background because that's the evidence before this Commission. And it's the reason why the Commission was interested in understanding from you why this was not reported as a reportable irregularity. Chair, that evidence came principally from Ms. Mshe, who gave evidence in the middle of last year, June, July of last year. Just for record purposes, her evidence is contained in Exhibit DD 15. Now, you'll recall, Chair, that what Ms. Mshe told this Commission was that SAA had gone out to tender for domestic lounge catering services. It had gone out to tender because at that stage, before the tender, its subsidiary Air Chefs had been providing that service, but there were concerns about the standards of the service, there were lots of customer complaints, and so SAA took a decision to go out and tender and see if it could improve things. Her evidence was that they ran a full tender process, that it was lawful and regular, that amongst the bidders for that process was Air Chefs, and that at the conclusion of the process, Air Chefs was not selected, but LSG Sky Chefs was selected and awarded a contract for 85.8 million rand for 3 years. Now that is the background to the Air Chefs tender that we received at the Commission. What Ms. Mshe also went on to tell the Commission was that there was an unfortunate presentation that the SAA board had to make to Parliament on the 2nd of September 2015, shortly after this process had been run. And Ms. Mshe's evidence was that during the presentation to Parliament, the chair of the board of SAA, Ms. Mieni, had received some tough questioning about the fact that SAA had chosen to award this tender to LSG Sky Chefs when it had Air Chefs, its subsidiary, who provided the services. And Ms. Mshe's evidence was that Ms. Mieni was not in a position easily to answer the questions, and that after that session, she became very angry and demanded from Ms. Mshe that the award be withdrawn from LSG Sky Chefs and awarded to Air Chefs. And she was supported in all of this by Ms. Kwinana. Mr. Motibe, were you aware of those facts when you were auditing SAA at the time?
Certainly not the detail that you are providing, Chair.
What did you know?
I was aware that there was a tender which was previously awarded to LSG, which Air Chefs had lost, but then a business decision had been made, was then taken to rather insource the provision of that catering to SAA lounges by Air Chefs. So what I was aware of is that there was a decision to rather insource the provision of service instead of giving it to a party outside the group.
Why would a state-owned enterprise, having run an entire tender process and awarded that tender to a third party, be able then to take a decision simply to insource those services?
Chair, as I indicated, it was our understanding was that this was a business decision that was taken by the board of South African Airways.
But is it compliant with the PFMA?
Chair, typically the decision to insource a service within the group, one would not see that to require a tender process.
I accept that.
Because, Chair, you set up a business to be able to provide a particular service inside, and it makes sense for you to get the service inside, instead, if you can get it within the group, Chair.
But when the very same entity has determined it should go out on tender, it has run an entire tender process in which its subsidiary was a bidder and was determined not to be awarded the tender. Would it not then be a breach of the PFMA if it was subsequently to be awarded the tender after it had been taken away from the party who had emerged in that process as the most competitive, cost-effective bidder?
Chair, what we saw was a review of a business decision, and that in itself, Chair, it is something that you see on a regular basis. As a board of directors, they do have a duty to make decisions and review decisions, Chair, as obviously following protocols. So, Chair, the decision to review the award of the tender in itself, Chair, would not have constituted an reportable irregularity.
And what if the board of SAA had been told that if it withdrew the tender from LSG Sky Chefs, it would breach its contract and it would be liable to exposure of the 85.8 million that LSG Sky Chefs was entitled to?
That, Chair, is then something that, yes, the board would have to consider in making that decision.
And it would be unlawful in those circumstances if that was the advice the board had received, because there are rules of law governing procurement, and there is a statute you may or may not be aware called the Public Promotion of Administrative Justice Act, which vests in the successful bidders certain rights. Are you aware of those legal provisions, Mr. Motibe?
Chair, that is not really one of that act is not really one of the ones that we have looked at, Chair.
Are you aware that the Board of SA at the time was advised by its own internal legal department that if it went ahead and did this, it would be acting unlawfully under the Promotion of Administrative Justice Act?
Chair, I became aware of it, Chair, when I saw the information here in the pack, but when we were conducting the audit, Chair, from the extracts of the minutes, that one, so no, I was not aware.
But you did confirm for us earlier that this was a particular award that you did consider, correct?
As in, yes, it was brought to our attention, and we are aware that, but the details they're being packed out, not in the kind of detail, Chair.
So you didn't call for the documents that served before the board when it took this decision?
No, I did not call for the documents, no, Chair.
Should you not have done that?
Chair, on the basis of the information that was provided to me, I took, because it was delegated, and we had requested a summary, an extract, all the salient features. I took it that all the information that I needed to make the decision was included in what was provided to me.
Okay, so I take it you didn't see the memorandum that Ms. Mshe prepared for the Board of Directors on the 20th of August 2015?
No, Chair, I did not see that memorandum.
You'll find that in Exhibit DD 19C, so that's the first file, Chair, at page 132.3.1, so 132.3.1.
I have the document, Chair.
You said C, yeah?
Yes, which is in fact in file 1, Chair.
Oh, okay. Yes, at what page?
We will start at page 132, 132.3.1.
Yes.
Thank you. Mr. Motibe, this is the memorandum that Ms. Mshe, as the acting chief executive, prepared for the board in advance of that fateful day before Parliament, admittedly. And what I don't want to read it in detail, we don't have time for that, but she provides the background to why they went out to tender. She catalogues the process that was followed. She indicates how the evaluation took place. And then on the last page, you'll see final recommendation. You'll see there under final recommendation, she records, it's hereby requested that the SAA Board of Directors note the final award to LSG Sky Chefs for a period of 3 years, from 1 September 2015 to 31 August 2018, at an estimated amount of 85,818,793 rands and some cents, inclusive of VAT. And she says, in this regard, and further to the lawful tender process, a third party will be performing services previously rendered by SAA's subsidiary company, Air Chefs. Ms. Motibe, at the time, do you know what the limit on the delegation of authority for the Chief Executive Officer of SAA was?
Issue I would not remember off the top of my head, Chair.
Okay, I can tell you it was 100 million. Okay, and that was the evidence of Ms. Mshe. I'm not just dreaming that up. So this was a decision that it was within her delegation of authority to take. Do you accept that?
I accept what,
If it was 100 million, she could determine that this should be awarded. Is that correct?
that sounds correct.
Yes. But then what happens is we have the interaction at Parliament. You have on Ms. Mshe's evidence, Ms. Mieni becoming very angry afterwards and demanding that it be taken from Sky Chefs and awarded to Air Chefs. And what Ms. Mshe then does in response is she sends an email to the board the next day setting out the whole process. And you'll find that in the same bundle, page 132.15.
Is it 15 or 50?
15, apologies, 15. I've started on the second page of this email train because it starts, in fact, with an email from Ms. Mieni to her co-board members and Ms. Mshe, to which Ms. Mshe then offers the response 2 days later. Let's just look at what Ms. Mieni says to the board and Ms. Mshe at page 132.15. She says, colleagues, I'm sending this to you first and foremost. This is not in line with what we're doing at Air Chefs as a shareholder. We have to review the submission, which was not submitted to the board for noting. Air Chefs is struggling, and I announced my concerns as the shareholder. Acting CEO, kindly hold this process until the shareholder of Air Chefs applies its mind. Now, Ms. Mshe responds to that over the page, which is back a page at 132.14. And I don't suggest we read it, but the essence of her response is to dispute that the board wasn't notified, because we've actually just seen the notification that they received, and she attaches it again. And then in her answer to point 2, which you see bold just below the middle of the page, there's a paragraph she inserts, and what she says there in the last sentence is, any holding and or cancellation of the award could result in litigation and financial exposure against SAA. Can I take it that you weren't aware of this email correspondence at the time?
Certainly, Chair, I was not aware of this email correspondence.
And there's a response to that.
I'm sorry, Ms.
Yes.
Hofmeyer. The last reading that you did was from what page?
Chair,
Was it back to Ms. Mshe's email?
Yes, it's on 132.14.
Or 14?
Yes, 14. Apologies, Chair.
Okay. Yes, okay.
And you'll see she's now responding to the chairperson. And what is bold is the text from the chairperson's email that we saw previously, and then the indented paragraph is Ms. Mshe's response.
Okay.
We've traversed this with her. And then under 2.2 there, that paragraph from Ms. Mshe, I was just emphasizing the last sentence, which is that her indication to the board was holding or cancellation of the award could result in litigation and financial exposure against SAA. And I was saying to Mr. Motibe for his confirmation, he was not aware of this email correspondence at the time. It has a sad developing history, Mr. Motibe, because Ms. Kwinana responded to Ms. Mshe's email later on that day, and you'll find that back a page at page 132.13. She says the following. I'm going to highlight some parts of it, Chair. You'll find it in the second half of the page on page 132.13. She says, I note that Air Chefs also responded to this bid, meaning that if it is not what they do, which I doubt, is something they would be able to do, why was the board not notified of this decision as per the submission? I pause there, Chair, because the evidence was that they had received it, but for some reason Ms. Kwinana and Ms. Mieni seem not to have been aware of that. She says, I recommend that the award be cancelled, and if they claim for damages, the letter was written on the 20th, and that is what they would have, and what is it that they would have prepared between the 20th and today the 3rd, unless they knew that the tender is theirs? I must take this opportunity to say I'm very disturbed by this decision, which is killing SAA subsidiary. As the chairperson of SART, I think she's supposed to say, it is making me very nervous where one day I will wake up and find that SAA fleet is serviced and maintained by a foreign company that competed with SART. My simple rhetorical question is, if SAA and its subsidiaries were owned by you, would you give business to your competitor even if you do exactly the same business? Chairperson, this looks like treason, and I request this to be investigated by the SIUs. So Ms. Mshe then thought she ought to get a legal opinion to back up her position. And so she did procure a legal opinion from the internal legal department at SAA. You'll find that at page 132.4. The numbering on my file seems to have gone on the side.
No 1 to 2.4 with me.
Chair, I think what happens is it moves to the portrait, the landscape, not portrait, allocation in the file. So if you go to 132.11, and then you go back a page.
Okay.
You'll see that the numbering moves to a different part of the page, unfortunately, because it's been printed oddly, which is unfortunate.
I think they should do a second
We will.
pagination in the right place.
And also this is unfortunate because it's on half of the page. So we will
Yes.
just turn it around,
Yes.
put it a portrait, and then put it
Yes.
at the right point of the page. But just for
Yes.
now, if I can just then direct you to page a few pages back, because then you'll see the start of this legal department's memo. I don't want to read large parts of it, but just to give you the background, what is set out in this memorandum is the background that Ms. Mshe already gave in her evidence, that it was a business decision to go out to tender because Air Chefs had been providing the service. There were numerous complaints. It was determined to see if there was a better service provider. They'd gone to tender. Air Chefs had been one of the bidders. It had not won the bid. And then the conclusion is really as follows, Mr. Mothibe. It's first that the tender itself, that process was run fairly and lawfully. It's second that if the award was cancelled, it would expose SAA to legal action and financial exposure, which would mean financial losses for SAA. It would be unlawful to withdraw the award, because it would breach the requirements of the Promotion of Administrative Justice Act. And finally, the legal department recommended that cancelling the tender would also undermine good corporate governance. And all of those issues were then presented to the board on the 8th of September by Ms. Mshe. I won't take you to the document now, but it is in the bundle at DD 19C, page 132.11. So, Mr. Mothibe, that's the background to this decision that the board takes on the 28th of September 2015, nonetheless, to withdraw and award to LSG Sky Chefs. And is it your evidence before this commission that none of that background came to your knowledge when you looked at this?
Chair, as I indicated, we had delegated the review of the minutes to one of the members of the team, and the extracts that were provided to myself did not include the detail that Mr. Hofmeyr is sharing. And in the absence of that, we did not believe that at this stage the matter would have been a reportable irregularity, Chair.
But shouldn't you have ensured that your team got relevant documents before it?
As I do indicate, the requirement is for the team to give an extract of the salient features. So when the matter was brought to my attention, my expectation was that what was provided were the salient features, Chair. And therefore, based on that, we did not believe the trigger for a reportable irregularity did not, it was not triggered, Chair. The census for that, Chair.
Do you accept today that these are salient features?
Chair, looking at this today, Chair, certainly one would have had to consider these matters, and as a matter of process, Chair, because of what it is to report or to raise a reportable irregularity, this would have gone through the necessary processes within the firm.
In your response on this, Mr. Mothibe, which you'll find at the beginning of that file, and which we've entered into the record as DD 19A at page 9, you say at paragraph 40A on that page that at the meeting, and you're referring to your heading of the 28th of September 2015, the board decided to retract the domestic lounge catering tender and award it to Air Chefs. And then you say in the sentence, it is suggested that this was done without following the bidding process. Who suggested that?
Chair, I will have to go back and look at the extract of my notes.
And why do you describe it as a suggestion that it was done without following a bidding process?
Chair, as I indicate, I looked at the extract that was provided to myself, and I would love to have a look at that before I can give a response, Chair.
Well, let's go, because the board actually uses that language itself when it resolved to take this decision. That it took at a meeting on the 28th of September 2015. You'll find that board minute in the same volume, DD 19, but now it's the C part of it, and you'll find it at page 132 16.3.1. That is the minutes of the special meeting of the SAA SOC Limited Board of Directors held on Monday, the 28th of September 2015. Is this a set of minutes you would have considered when you were conducting the audit?
Apologies, I seem to be on the wrong page.
Apologies.
132.
132.16, 16.3.1.
Oh, I am also in the wrong.
Sorry.
I missed the 3 before the 1.
Apologies.
Same here, Chair.
Oh, sorry. So 132.
No, I think, Mr. Mochibe, if we both got it that way,
Maybe
Ms.
I
Hofmeyer must have misled us.
I must have misled you. I do apologize.
Yeah, 132.16.3.1.
Indeed. Thank you, Chair. Mr. Motibi, do you have it?
I've got it now, Chair.
And my question to you was, were these amongst the minutes that you would have considered when you were doing your audit work for the year?
Chair, as I mentioned earlier, we had delegated this role to review minutes to one of the team members. So I wouldn't have seen the full minutes. I would have seen extracts of the key features, what were the important issues pulled out of the minutes. So I would have had full sight of the minutes myself, no.
Mr. Motibi, do
A
you...
team member of
Sorry.
mine would have had access to minutes, yes.
Do you accept responsibility for the work of your team?
That is correct.
Right. So ultimately, whatever processes you put in place, they must be good enough that your team is doing what they should do, correct?
That is correct.
Right. Do you recall that you were actually yourself sent a copy of these minutes?
Chair, as I did indicate, I did not see the minutes. I saw extracts of the minutes. The minutes itself, no. I only saw extracts of the minutes on the page.
But you were sent these minutes. So why do you persist in saying you only saw extracts of them?
Because I do not, the review of minutes is delegated, Chair. I do not read the minutes myself. That work is delegated, and the team is required to provide me with extracts of minutes, indicating all salient features, all critical issues that I needed to be aware of.
Right, so you don't dispute that you were sent them. As I understand your answer, you might have been sent them, but it wasn't your responsibility to review them. Is that correct?
The responsibility to review minutes was delegated, Chair.
And you accept responsibility for the adequacy of that review?
That is correct, Chair.
So the person in your team who reviewed these minutes would have come across the item dealing with air chefs and would have found that at page 132.16.3.15.
Okay, Ms. Hofmeyer, there are too many points and points now, so start again, tell us again, 132,
0.16, 16.3,
yeah,
0.15, 15. Chair, this, when I see these numerous numbers, I shudder. I apologize.
and I don't seem to have you said 132.16.3.15.
Yes, it's actually, if you take the internal numbering of the minute, which you'll see at the top middle of the page, it's page 15 of 17, if that helps, Chair.
Hey, at long last.
And it's late in the day. I think we're all,
Whoever did this numbering, please talk to them.
we have to have a
some
better
of us
method.
are not accountants and
No, no.
auditors, so when you've
Indeed.
got so many, such long numbers, it's difficult. So they can do it, they can find a shorter
Yes.
way of doing it.
Certainly, Chair. Do you have internal page 15 of 17?
I found it. I think
Thank
Mr. Mutibe found it before I found it.
I've got it, Chair, thank you.
I want to start with what the board resolved, but there's a lengthy discussion in these minutes about the background, what had happened, that Parliament had raised concerns, etc. But then you'll see just before the first "it was resolved" on that page, there's an entry that Mr. Dixon, who was one of the board members, declared that he reserved his vote until he fully understood the risks of cancelling the award to the airline. And then there's a resolved, it was resolved that A, the SAA Domestic Lounges tender award be retracted, and B, the catering contract be awarded to Air Chefs without going through the bidding process. Now, Mr. Motibe, if one of the obligations of auditors of SOEs is to determine compliance with the PFMA, and I take that you've accepted in your evidence, is that correct?
That is correct.
And a member of your team reads this resolution in the board minutes on the 28th of September 2015, that the SAA Domestic Lounge tender award be retracted and that the catering contract be awarded to Air Chefs without going through the bidding process. Do you accept that that should have sounded an alarm?
Chair, there would have sounded an alarm.
And more should then have been done and required of management to explain why it was that a tender that had been awarded was now being retracted and without going through a bidding process. Do you accept that?
Chair, as I indicated, yes, there should have been an alarm, but also other factors need to be considered. And obviously, in inquiring, in getting an understanding as to why they're going through what they're going, you then arrive at the reasonable conclusion.
I just want to make sure that we are all on the same page. Would a member of your team reading these minutes have immediately known that HFs was a subsidiary of SAA?
Yes, Chair, they would have known.
Yeah. Now, if they would have known that, would they have been concerned about this part, even if they took the view, which I think you expressed in your statement, that awarding the contract to HFs would be insourcing, and therefore, in terms of the view you expressed, there would be no obligation on SAA to go out to tender?
Chair, there would be a reasonable thing. There would be reasonable also for them to take that view, Chair.
Yes, but the point of what I'm asking, I'm trying to evaluate your answers to Ms. Hofmeier's questions, whether if that's the view they held, that this would be insourcing and that it would not be necessary, or there would be no obligation on SAA to go out to tender. would this have raised a red flag or not?
Chair, if the view taken was, if they took a view that this amounts to insourcing and it is a business decision that is taken, Chair, it may not necessarily have raised red flags, Chair, no.
Okay, I just wanted to check if we might not be on the same page, but I wanted everybody to know what my query was.
Indeed,
Of
Chair.
course, whether or not there would have been an obligation to go out to tender or not might be another issue that might still be looked at.
Indeed, Chair. Thank you. If your team member had read the preceding discussion in this minute, Mr. Motibe, he would have noted, or she would have noted, on the previous page, that's 132.16.3.14, that the CFO had made a remark against the letter G on that page. See, what the CFO said there is that he was not in disagreement with the sentiment that the business should be given to air chefs. But in his capacity as CFO, it would be remiss of him not to mention that the bottom line impact for the group, should the tender be awarded to air chefs, was approximately 4.5 million, which was far less than the exposure of 85 million should SAA be sued by the preferred bidder for the full contract price. Do you see that?
Read that paragraph, Chair.
So again, just probing what you would have expected of your team member, taking the chair's point as our starting point, and in deference to your team member, maybe when just the resolution is read, there's some understanding that this is just an insourcing decision. But, Ms. Motibe, if your colleague had also read G, would not a red flag have gone up? Even if this is insourcing, there's a risk of 85 million rand exposure for SAA if they take this step.
Chair, obviously, being wary of not using hindsight, because some of this information was certainly not available to myself when that assessment was made. I think in reading this, you definitely would have to consider the implications of this financial loss to the entity and consider whether that there's other obligations that we may have had.
And apologies, Chair.
Apart from this, and maybe even if he or she did not see this part of the minutes, what about if he or she knew, because I think he or she would have known, that a previous decision had been made already to award the tender to an outside company? On hearing that a decision was taken to revoke that, would that not, and give it to a subsidiary, would the fact that a decision had already been made to award the tender to an outside company not also have been something to be concerned about? To say, well, if you have already decided to take, go out on open tender, and you have decided to award the tender, can you just take it back like that, retract it, and give it to an internal entity? Is that the kind of thing that would not have raised a red flag, or not really, as you understand the position?
Chair, it is very difficult because now I'm obviously responding having read what I've read and having listened to what Mr. Fumere has presented. And I'm worried that one is using hindsight and that.
Well,
However, Chair,
let me maybe put you at ease. when one is dealing with this kind of situation where you're thinking of what would have been, what reaction could be expected from somebody in a certain situation, there may be situations where you are able to say outright, of course, this would have been a red flag. You know, there would be situations where you say no, and then there would be situations where you say, I'm not sure. So that might be a measure that's helpful, a tool that's helpful for you not to use hindsight. So what are you able to say? Because the questions that are put to you by Ms. Hofmeyer are aimed at establishing whether somebody should have picked up that this was a potential problem and therefore taken certain steps.
I understand you, Chair.
Yes.
Yes.
So going back to, I think my question, because I think it was my question that you were trying to deal with, simply knowing that the company had gone out on tender, bidders had put in their bids, and a decision had been made to award the tender to an outsider. If they are now suddenly retracting it, would that be something that, on your understanding, should raise a red flag with a member of your team?
Chair, I would think there would have been reason to ask more questions on the.
Yes. Yeah.
I think there would have been reason to ask more questions,
Yes.
Chair.
Okay. Ms. Hofmeyer.
And Ms. Motibi, if we read further in the background to this decision taken by the board on that day, I don't suggest we read all of it, but I can tell you that in paragraph D on page 132.16.3.14, the point is made that the business decision was taken to go out to tender because Air Chefs had in recent years been damaging the SAA brand due to poor offerings. So the person reading these minutes knows that fact, right? Knows a business decision was then taken to tender. The reader of the minutes knows that the CFO is saying if we move this to Air Chefs, there could be exposure of 85 million rand to SAA. And furthermore, the reader actually also knows that the genesis of this difficulty is the questions that the chairperson faced in Parliament, and you find that at I on the page. There it's recorded that the chairperson highlighted that some members of Parliament at a recent meeting of the Standing Committee on Finance had raised a serious objection to SAA awarding a catering contract to a foreign-owned company whilst it had a subsidiary which offered the same services. It might have been useful for Parliament to be told, but we understand from Ms. Mshe it wasn't, that the reason why that happened was because a valid tender process had been run and LSG Sky Chefs had come out on top. Unfortunately, Parliament wasn't given that insight, but all of that background is then before the reader of these minutes. And I take your evidence before the Commission today, Mr. Motibe, to be this should have raised a red flag and more questions should have been asked. Is that correct?
That is correct, Chair.
Now, in your statement to the Commission dealing with this, you said it was not necessary to follow a bidding process. Why did you say that?
Chair, it was based on the extracts of the minutes that I had read.
As you sit here today, does that remain your view?
Chair, as I did indicate earlier, with this information, there was a need to ask more questions, Chair.
The board certainly knew it was required to go through a bidding process, didn't it?
From the reading of this, it does look like that, Chair.
And we know as a fact, management had warned it against withdrawing the LSG Sky Chefs award, hadn't it?
From the minutes presented, it is the case, Chair.
And it had been told in the legal opinion that it would be unlawful for it to cancel that award, correct?
That is correct, Chair.
Now, Mr. Motibe, in your statement dealing with this issue, as I read it, you first of all say no bidding process was required, but you've now fairly conceded in your defense, Mr. Motibe, that the person reading these minutes should not have come to that conclusion. But you say in the alternative, let's go to page 9 of your statement, just so that you have it in front of you at DD 19C, A, page 9. You say you cater for a different situation where the bidding process was required. And that's at the bottom of page 9, the last paragraph, the second sentence in. You say, assuming that a bidding process was required, which I am advised it was not, but we're working on your assumption now, I would have required evidence that the SAA board took this decision with the intention of breaching a law or regulation, or that it acted negligently, which evidence I did not have at the time. Consequently, I had no reason to believe that a reportable irregularity took place. Just want to pause there for a moment, because this is a point you repeat a few times in your statement. As you've captured the reportable irregularity obligation there, you seem to be indicating that you thought that as the auditors of SAA, you didn't only have to find unlawful conduct on the part of a person responsible for management that had those consequences we looked at. You seem to be saying you also had to find that that decision was taken with the intention of breaching the law, or that it was done negligently. Ms. Motibe, I don't see that requirement in the Auditing Professions Act. Do you?
Chair, in the extract that I've put in here, the requirement is not included there, Chair.
Please raise your voice.
I was saying, Chair, in the extract or in the definition or understanding of the requirements to report reportable irregularity, that matter of intention is not mentioned, Chair.
So then I want to put it to you that it was not required of you that you were to establish whether this was done with negligence or intention, was it?
Chair, I would like to have a look at the full, I think the full act, because Chair, certainly the question of intention, Chair, if my memory serves me right, I think is a requirement, but I'd like to confirm that, Chair.
You may need to have a look at the act if you wish to, but let's see if we can't deal with this in a different way. When you say in that paragraph that you would require there to have been evidence that the board took this decision with the intention of breaching a law or regulation, what did you mean?
Chair, earlier in the statement, I do mention that the understanding was that it was a business decision that has been made to have the catering to be insourced to air chefs. So, Chair, is to say that if there is a genuine business decision that has been taken, much as the board may have erred, Chair, let me rephrase that, Chair. the three requirements here, Chair, talk of a material financial loss. It talks of fraud amounts to theft, or it talks of material breach of fiduciary duty. Chair, where these elements occur, Chair, you do sometimes you find that there's an intention, the action taken is there genuinely to defraud or to cause financial loss or to breach laws or regulations and breaching fiduciary duty. I think, Chair, earlier when I responded to Ms. Hofmeyer's question, I did indicate that there's also an element of judgment that is involved. Albeit, as Ms. Hofmeyer said, is that the bar might be low. But it is important to understand why decisions are made, what was the intention. And Chair, if there's an intention to break the law, that makes it that makes it easy for one to make the call, Chair. But where there were genuine business decisions that were being followed, and it resulted in a breach of law or an omission, Chair, I think that's where one then begins to apply judgment in determining whether or not this was in fact a reportable irregularity or there were some other issues to be involved. And also importantly, Chair, I would obviously would have had to consult with within the firm to ensure that I have properly applied my mind to the matter.
Well, let us say that, let me tell you what I think what my understanding of what you were saying there is. It is that you are saying that you would not consider if, for example, the board said, don't take this to open tender. But in saying that, they were in good faith. You would say the failure to go out to tender is not an irreproachable irregularity. If it is an irregularity, just because they were in good faith, they were acting in good faith. They did not believe that what they were doing was unlawful. But if that is what you're saying, I'm concerned. Is that not what you are saying?
No, Chair, that is not what I'm saying, Chair.
Well, what are you saying?
No, so I'm saying, Chair, that when these incidents do happen, you need to get the full facts behind this and get an understanding of what transpired. As soon as it hits all the necessary triggers for a reportable irregularity, I would also then follow a process to consult within the firm to make sure that my understanding is correct, Chair. One of the things that you do consider, Chair, is obviously intention. As I indicate, as soon as there is intention to breach law,
yes, I think that
makes it easy.
That is what we are concerned about, because if the law is, if you are going to obtain these services, you must go out to tender, and the entity decides not to go out to tender, and that decision exposes the entity to financial loss, serious financial loss. Why is that not reportable, a reportable irregularity?
Chair, maybe if I can give an example. When one looks at non-compliance matters, if you don't comply with the law, one may argue technically that you've broken the law. And therefore, then does it become a reportable irregularity? So then there'd be many items that needs to be reported. So I think all I'm saying is that the areas where one has to think and apply judgment, but I'm certainly not saying that it is only about intention. That's certainly not what I'm putting forward, Chair.
Well, I don't know.
if-
Ms. Hofmeyer may take it further, but maybe where you are required to be satisfied whether you are dealing with a situation of fraud, maybe in that situation might be your concern about intention might be understandable, even though, as Ms. Hofmeyer said earlier on, and you agreed with her, that the bar for purposes of reportable irregularity is lower, But maybe there might be something there, I don't know. But other than that, if the law said you must go out on tender, and you don't go out of tender, it doesn't seem to me that your intention is of any relevance. Do you agree?
I hear where the chair is coming from.
Yes, you hear, but you agree.
Yes, I do agree, Chair.
Okay.
That I do agree, Chair.
Okay.
Yeah.
Thank you, Chair. And just to follow that up, because Chair, you've highlighted in your questions the first of the three criteria for the reportable irregularity. It's the unlawful act plus material financial loss. As you've put it to Mr. Motibe, there's no intention relevant to that, and Mr. Motibe has fairly conceded that. I want to submit that also in relation to the third, a material breach of fiduciary duty, intention is not referenced and not relevant. Do you accept that, Mr. Motibe?
I do hear where you're coming from, Chair.
Do you accept it?
Do you accept that as correct?
I accept it as correct, Chair.
Okay.
Thank you, Mr. Motibe. It just helps, and also for the record purposes, that we know the common ground between us. Right. So my next question then is to reevaluate what your team did. Because as the chair has put it to you, if there was a requirement to go out to tender, indeed they did go out to tender, a third party was awarded the tender, but then it was withdrawn. Then you have the requisite first unlawful act requirement, don't you, for a reportable irregularity?
Yes, if there's a requirement to go and tender, which I was advised, it was not.
You were advised how? You spoke about being given a sort of synopsis from the team that said this was insourcing. Did they actually positively state there was no need to go out to tender for this award?
Well, Chair, an insourcing arrangement is it's something that you do within the. You've gone out and set up a business process, and you are now taking it forward and delivering within your business, Chair. So something like if you are insourcing, Chair, it does not require a tender. And in the discussions that we had, insourcing does not require a tender, Chair. It's not a requirement.
And if it was required, we've got the unlawful act. Was it committed by a person responsible for management of the entity?
1 second, Ms. Hofmeyer. I see the noise is back, but I don't know whether we are warmer with the noise back or whether we are worse off. I feel quite some cold.
Yes.
So I don't know whether the aircon was switched off temporarily and then later on it was brought back, or whether it's controlled centrally and therefore once it's on, it's on. But I think I do see that I'm not the only one feeling cold.
Chair, can I make the suggestion? We're just at 4 o'clock.
Yeah.
Maybe we should just talk about arrangements and how much longer, because if we are to go on, maybe we can have a short adjournment, comfort break. We can establish what the position is in the room and try and get the best warming conditions and then return if you're in a position to do so. I did check with Mr. Motibe and his legal team. They are in a position to remain beyond 4 today, if that's suitable, and then see how we go.
What's your estimate of how much more time you need?
Chair, I always reluctantly give these estimations. Whenever I think something's going to be quick, it always takes much longer. But I can tell you that I'm about 2/3 of the way through my questions.
Yes.
So there'd only be a third more, but reportable irregularities we've covered, and there's only a second example of it. And then there are 1 or 2 more things. I think if we took another hour, I'd make a good advance in completing, but we may well need to still reconvene tomorrow for a bit.
Yes, okay. Well, the question that if we are going to need to convene tomorrow, it may be that we shouldn't try to go much further, but it may well also be that we could go up to 5. I have more flexibility tomorrow than I may have made you believe some time back. So tomorrow I'm able to sit for quite some time, but I don't mind us going up to 5 today. It's just that, of course, if we go up to 5 and Mr. Motibe and his legal team have to come back tomorrow for 1 hour, it might not be such a good idea to go for another hour rather than take 2 hours tomorrow, but I'm not sure. Maybe Mr. Motibe, are you flexible either way, or what's your position?
Chair, I'm looking at my team, but I'm happy to, if it means 5 o'clock, we can wrap it up. I'm happy with
but
that.
you are happy with tomorrow as well?
I'm happy with tomorrow, but Chair, obviously, if we can get it done today, it's preferable.
Ms. Hoffman, shall we go up to 5 and see, or how it goes, or what's your own sense?
My own sense is it would be advantageous to take the extra hour. It just means we're going to safely finish tomorrow with our second witness. We also do have to do some logistical things tomorrow, and if there's any delay there, I don't want that compromising us. So maybe we take the extra hour.
Okay, maybe then let's take a short comfort break, and then we'll come back and do an hour, which might take us to just after 5 o'clock, and then we adjourn.
Thank you, Chair. We're indebted.
We'll adjourn for 10 minutes. We adjourn.
All right.
I am still required to take it through a process, through a consult internally with our legal division before the final call is made, Chair.
Well, let us say you are auditing SAA now. You come across this, and the facts are or include that this decision by the board could result in SAA being sued for damages to the amount of 85 million rand by the successful company. Would you regard that as, would you regard the decision by the board to withdraw that tender and give it to a subsidiary as a reportable irregularity on those facts?
Chair, as I indicated, I would definitely gather all those facts and consult as required by our processes in PwC. So, Chair, the decision to determine whether or not it's a material, it's a reportable irregularity would not only be mine as the engagement leader. I am required to consult internally to
What more would you look for in order to make up your mind whether, in your own view, the test for reportability is met, which Ms. Hofmeyr said is, it puts a low bar?
Chair, as I indicated, all these requirements would probably have been met. And therefore, Chair, I would have put together the documentation that's necessary to say, these are my views. I do believe there's a potential reportable irregularity. Then I would have to submit that through our consultation process so that they can confirm my thought process before I would report to the regulator if they agree with me. So there is a process that needs to be followed, Chair. I do not make the decision on my own.
But is it correct that as you sit there, when you hear these facts, your own view, leave out whether somebody else might persuade you differently, or your own view would have been this was a reportable irregularity? In the light of the potential litigation and the amount involved, and
Well, Chair, our materiality level at South African Airways was set at 250 million. So the potential damage of 285 million would have been below the threshold of 250 million. So, Chair, one would have. That is why it's important that, because of the other elements that have been breached, it is imperative for one to consult to make sure that you make the right call.
I'm sorry. These these requirements are not isn't the position that each one of them is enough
Indeed, Chair.
to make the irregularity reportable, isn't it?
Chair,
You don't need to have all three. Yes.
That's correct, Chair.
But I think you already conceded, and you must tell me if you didn't, when Ms. Hofmeyr was asking you, that the one appearing at 3 on page 9 of your statement, you said that one is met. Is that right? It was met in this
Chair,
case.
you're talking about the material breach of fiduciary duty. Yes, Chair.
You agreed with that one. I don't know, number two might not, I don't know, yeah. So the one relating to an act that is likely to cause material financial loss to the entity or to any partner or member or shareholder or creditor. That one, do you seem to have some doubt whether that one was met?
Chair, yes, because the amount is below our materiality level of 250 million.
Yeah.
I do obviously consider that the breach was by somebody in management. And also, Chair, my assessment has got to be tested and by somebody else to ensure that I've correctly assessed what has been. The result, Chair, I say I would have to put all the facts together, including the amounts, well, and the fact that there was a breach of fiduciary duty, Chair.
Okay.
Thank you, Chair. Ms. Motibi, I just want to pick up on this point that you've emphasized in your recent answers to the Chair about you would need to go to others at PwC to run your thinking past them. Do I understand your evidence correctly when I say that's what you've emphasized?
Chair, that is correct. Once such has been identified, there's a process that we follow within PwC to ensure that we have correctly assessed the supposed reportable irregularity, Chair. So there is a process we need to follow. I wouldn't do it on my own directly, Chair, no.
But Mr. Motibe, apologies, do you accept that the obligation under the Act, the Auditing Professions Act, is an obligation that falls on you?
The obligation does fall on me, Chair, but I do take guidance.
But it is therefore, I would put to you, fair for us to ask you what your determination was, because the obligation under Section 45 you've accepted is an obligation on you, is that correct?
That is correct, Chair.
And that should be read, I suggest, with Section 52, which indicates that a registered auditor who fails to report a reportable irregularity in accordance with Section 45 shall be guilty of an offence. Are you aware of that section?
I am aware of that section.
So if you as the individual registered auditor of SAA had failed to report a reportable irregularity, then it is you who would have committed that offence, correct?
That would be correct.
Thank you.
The process that you talk about of consulting others within the firm, would its purpose have been to enable you to form a view whether this was a reportable irregularity, or would its purpose not have been to help you form a view, because you would have formed a view, but maybe it is a process that you are required to follow in terms of the policies of the of the firm, irrespective of what view you have taken?
Chair, I would have taken a view, and that, Chair, as I did indicate, some of these matters might require judgment, and it also helps me to ensure that I've considered all the matters that I would have considered, Chair, in order to determine whether it is or it is not.
I'll tell you why I'm a little concerned about your evidence, if I understand it correctly, or at least why I seek clarification, because it seems to me that you are quite senior within the firm. You know, I think you said you became a partner in 2003 or 2002, is that right?
2003, Chair.
Yeah, I mean, you are close to 20 years as a partner now, you know, and it doesn't appear to me that this particular requirement is a complex requirement. So I'm wondering why you would need that consultation process, whether you would need it in order to form a view, or whether within the firm there is an internal arrangement to say, if you think a particular decision is reportable, you must have a consultation process. In other words, whether you would be doing that process to comply with the internal policies or whether you would be doing it as part or as a process towards you reaching a decision or reaching a view.
Chair, there is certainly there is a compliance requirement with
Yeah.
PwC to that.
Yeah.
We do have that.
Yeah, but you would have taken a view on your own.
Yes, Chair. I mean, Chair, the fact that you triggered that means that you've already seen something and something has triggered that.
Yes.
So then you need to go through necessary compliance, Chair, to make sure
Okay.
that you got it right, Chair.
Mr. Motibi, I'd like to move to the second contract of which I am interested in the topic of reportable irregularities. And that is going to be the Swissport ground handling contract. And you start to deal with that in your statement at page 10. That's in DD 19A at page 10 towards the bottom.
I've got it, Chair.
Thank you. Now, Chair, you'll be aware, Mr. Motiba, I'm not sure whether you'll be as aware as those of us who live the Commission every day, but the Commission has received extensive evidence about this contract that Swissport concluded with SAA in March of 2016 to provide ground handling services for a period of 5 years, and it was to the value of 1.8 billion. And we've also heard evidence in this commission that it was awarded that contract without a preceding procurement process having been followed. So to give you the background, that puts it for us on the radar of a substantial contract of significant value in respect of which there was no procurement process. And so we asked you to address why that was not reported as a reportable irregularity. So let's go, if we may, to page 10 and what you say about it. And really your answer begins over the page, the one I want to focus on at page 11. It's the second paragraph from the top of the page. You say, during the performance of our audit procedures in respect of the financial year ended 31 March 2016, the agreement with Swissport did not form part of our testing sample. I was not aware of the board resolution nor the circumstances surrounding the award and conclusion of the Swissport agreement. In the circumstances, in the absence of such knowledge, I did not consider whether this matter is or may have been a reportable irregularity. Mr. Motibi, the first thing I noticed about that one is different to the Air Chef's contract, as I understand it. On the Air Chef's contract, you were aware of it, but at the time you'd concluded it wasn't a reportable irregularity, correct?
That is correct.
And in this occasion, you actually didn't consider it. Is that correct?
Chair, I was not aware of this contract, therefore I would not have been able to consider it.
And how could it be that you weren't aware of the contract?
Chair, according to my knowledge, the contract was concluded on the 14th of March in 2016. When we initially requested board minutes from SAA, the minutes of this meeting were initially not available to us. So, Chair, we would have been aware of that approval. Chair, I think it is also important to note, Swissport is a long-standing service provider to South African Airways. I stand to be corrected, Chair. I think there are 3 or 4 ground handling companies that provide services to South African Airways, with Swissport being one of them. So, Chair, and the amounts are fairly similar in that regard. So, Chair, a contract entered into with SAA to provide ground handling services by Swissport on its own would not necessarily have, understanding the business and who are the service providers, would not have necessarily been odd if they were seen. Even if one looks at the amounts involved. Chair, if the contract is awarded on the 14th of March, you think, had you seen the contract, the services provided would have run from what one has read now in the documentation from April going forward. So for the period of 31 March 2016, there wouldn't have been any expenses flowing from that contract. So, Chair, as indicated, at year end, when you requested the minutes of the board meetings, those minutes were not available to us, so we wouldn't have identified that. And as I do indicate, Chair, on its own, the board awarding the contract to Swissport, also because of the amounts involved, we would expect that such approval shall go through the board of directors because the amounts were, in terms of delegation of authority, the amount was fairly high. And obviously the expectation would be that it would have gone to the board after it had gone through the necessary approval processes within South African Airways.
But Mr. Mothibe, it went through no process at all, this contract.
Chair, as I do indicate, at year end, when we went in, the minutes giving that approval were not available. But secondly, Chair, as I indicated, a decision by the board or an approval of the Swissport contract at the board, because of the quantum involved, they wouldn't necessarily raise any concern because the amounts would be so high, they are above the authority of all other levels, and it is in fact required to come to the board for approval. So on its own, it do not have necessarily given cause for concern, if one can put it like that.
But Mr. Mothibe, you've already confirmed in your evidence that one of the things that you do as auditors of state-owned enterprises is determine whether any expenditure is irregular under the PFMA, don't you?
That's correct.
And the mere fact that it falls within the board's delegation of authority does not answer that question, does it?
When you do the determination, yes, you will select a sample that gets tested to determine that. This contract, at year end, those minutes were not available, was not selected for testing purposes. We did select contracts for testing purposes, but the Swissport contract was not one of them.
Mr. Mothibe, I'm aware of your position on sampling, but that was not the question I asked. The question I asked was, the mere fact that the amount of a contract falls within the authority of the board to approve is not enough to answer whether that contract constitutes irregular expenditure, is it?
Chair, that is correct, but for one to determine whether or not that contract falls within the definition of an irregular contract, one would have had to look at the procurement process. We would have to follow the procurement process to determine that. Because the contract was not in my sample, we did not follow the procurement process for this particular contract.
Yes, okay, I think let's
I
go.
would not have been able to determine
Let's
that.
go step by step, Mr. Mothibe. I think your answer to Ms. Hofmeyer's question is yes. You have provided quite some explanation, but it seems to me that your answer is yes. She asked you, do you not agree that the mere fact that the amount of the contract falls within the authority of the board is not enough to say this contract doesn't constitute irregular expenditure? And it seems to me you are saying we have to look at the procurement process as well, which seems to suggest to me that you agree with her. So I think you say, yes, I agree. It's not the only issue.
Yes, Chair.
Yes, then she might ask you further question, but to that question, an answer that says yes is enough.
It's a yes.
Yeah, okay.
And in fairness to you, we'll now look at the sampling question. Well, in a moment, because the one thing I just want to pick up on is you've indicated that those board minutes were not made available to you, and that is why you didn't pick up the contract. Is that right?
At the stage when we performed our work and when we did a sample, those minutes were not yet available to us.
Should you not have been intent to ensure that you had all the board minutes for the relevant year that you were auditing?
Those minutes were made available to us at a much later stage. So yes, we did have some of those board minutes, but it was at a much later stage.
Sorry, say that again. You were given them at a later stage. Is that correct?
But not, yes, but not when we were doing our sampling and we were doing our work.
Okay, but then, irrespective of time, if pursuant to your audit work, even if after the sampling you are given the board minutes and the board minutes raise concerns about reportable irregularities, do you accept that you would have obligations to follow the procedures required?
May I ask that you repeat the question?
Yeah. I understand you to say you weren't given them these board minutes reflecting the decision
Yes.
in April or shortly after the year end. Is that correct?
That is correct.
But you were given them, correct me if I'm wrong, at some point before you signed your audit report on the 30th of September 2016. Is that correct?
That is correct.
And then I put to you that it doesn't matter, as I understand it, when you come to learn of the subject matter of a reportable irregularity. If it is a reportable irregularity, you must report it. Is that correct?
That is correct.
Thank you. So then let's go to why it wasn't in your samples.
I'm sorry. I think implied in Ms. Hofmeyer's last question, to which you have agreed, is that as long as you have not signed your report, if something comes to your attention that may indicate that there is some irregularity, you are supposed to look at that before you sign.
That is
That's
correct.
right.
Chair. That is
Yeah.
correct, Chair.
Okay.
Thank you, Mr. Motibe. Then let's go to the question of why this 1.8 billion rand contract did not find its way into your sample. Okay, because I understand that from your statement to be part of your explanation for why it wasn't on your radar for a reportable irregularity, and you've repeated that today. So with that background, I'd like to remind you of what Mr. Sokumbela's evidence was before this commission. See, Mr. Sokumbela assisted the commission in understanding how audit risk assessments are done. And I want to just understand whether you have a similar understanding to Mr. Sokumbela. Okay. Mr. Sokumbela's evidence, and Chair, just for the record, this appears in the transcript of the 20th of February of this year, 2020, at page 88, and then also at transcript of 21 February 2020 at pages 8 to 83. So what Mr. Sokumbela told this commission is that an audit risk assessment is designed to identify contracts that raise red flags. Do you accept that?
That is correct.
And he also went on to say the flags could be raised by things like controversy in the media, or because when the auditors conduct their research processes, something about the contract concerns them. Do you accept that?
That is correct.
And he enlightened us as to why the Auditor General had identified the Swissport contract as an audit risk. He said that there was litigation around it, of which he became aware. There was a discovery that Swissport did not have a requisite license. And he also highlighted the fact that it had taken a number of years for the contract to be concluded. If those items had come to your attention, would it have constituted a red flag for you?
Chair, I think it is important to note that I consider the matters that come to my attention when I perform the audit. As I do indicate, Swissport was a long-standing service provider to South African Airways. The value of the contract, correctly so, because of the amount, had to go through to the board because of the delegations of authority. When we reviewed the minutes, seeing Swissport there and the number, the quantum involved, on its own did not trigger any concerns. Because if you look at the amount involved and what they had been paid over the years, and we do know that they are contributing service provider to South African Airways. So on its own, those that did not trigger any concerns, Chair.
Sorry, Mr. Mothibi, I see you were continuing.
I wanted to say, Chair, Mr. Hofer makes reference to, if I had it correct, did you say investigations, which we were not aware of when we performed our audit? So there would have been an item, issue that could, of course, want to open your eyes much wider, to raise red flags, but at that stage, we did not have that available. So it did not trigger at that stage that there is more to it than what we had been provided.
Mr. Mothibi, I'll come back to the question of investigations, but you've emphasized a few times the fact that Swissport was in an ongoing relationship with SAA. And as I understand your evidence, that's why when you saw later in the year before you signed your audit report that this big agreement had been concluded with it, that didn't on its own raise an alarm. Is that correct?
That is correct.
Mr. Mothibi, were you aware when you were auditing SAA from 2014 right up until this point that Swissport was being paid every month without there being any contract in place?
No, Chair.
Would it have concerned you to learn that it was being paid all throughout that period with no contract?
It would have been concerning, yes.
It would have been something you'd wanted to have interrogated further, would it not?
That would be correct, Chair.
Because what actually happened was a tender process was run in 2011. Swissport was awarded a contract for 5 years in 2012, and then at no point from 2012 was a contract ever concluded with it. Did you pick that up in your 3 years of auditing at SAA?
Chair, on the items that we selected for sampling, Swissport was not part of those.
Never in all 3 years.
Chair, I can go and confirm on my files, but I do not recall seeing that, Chair. Remembering that, Chair, the universe of contracts in SAA, you've got quite a number of contracts, Chair. It is a fairly big universe, Chair.
But it's a requirement of the auditor of a state-owned enterprise that they check whether the disclosed amount of irregular expenditure in the financials each year is verified. Is that correct?
That is correct.
How do you do that if you don't check what is being expended against the existence of underlying contracts for that expenditure?
You check that, but the contracts on a sample basis.
Okay, so we're back at samples, and what I was taking you through was Mr. Sokombela's indication about the audit risk assessment, which you accepted, and particularly red flag contracts. You see, Ms. Mothibi, my understanding of Mr. Sokombela's evidence is that before you even get to sampling, and this was a point, Chair, you might recall you sought greater clarity on with Mr. Sokombela, before you get to sampling, there are certain high-risk contracts, red flag contracts, that because of your risk assessment, you are going to be considering before you even get into sampling. Do you accept that?
Chair, I don't think I want to necessarily comment on the approach taken by Mr. Sokombela when he performed this work. But safe to say, Chair, yes, you do identify material contracts, and to the extent that there are concerns or issues, you will include them in your samples.
But as I have your evidence, you did not identify the Swissport contract as a high-risk contract, correct?
This particular contract was not identified at high risk in 2016, Chair.
It had been picked up, Swiss Sports Contracting with SAA had been picked up by Ernst & Young, who did a review in the second half of 2015. Were you aware of that?
I'm aware that Ernst & Young was contracted to do some work on long-carrying contracts and some that were over. So I am aware that Ernst & Young was appointed to perform work at the Sovereign Airways, yes.
It was actually appointed to consider procurement and contract management within SAA. Were you aware of that?
That is correct, yes.
Yes. And they were doing it for the second half of 2015, correct?
That is correct, Chair.
So would it not have been something you wanted to consider as the auditors of SAA, what the outcomes of that process had been conducted by Ernst & Young?
Chair, we certainly had interest in that assignment. However, at the time that we signed our audit opinion, that work had yet to be finalized.
Did you ask for any reports that Ernst & Young had prepared in the course of the year?
We had engaged with management, firstly to understand the scope of the contract or of the work that they had to perform. We understood that they selected, I think it was 3 items each under 4 different headings, Chair. And as I indicated, Chair, when we inquired of management, that work was still ongoing and the contracts had not been finalized. Due to the fact that it was also, there was an element of forensic work that was going on, Chair, it was something that took some time to complete. And when we signed our audit opinion, that final report had yet not been completed, Chair.
I just wanted to get clear on the facts. Did you ask to see, albeit not a final report, any version of the report that Ernst & Young had prepared?
We had requested to see a report from management, and I, for one, Chair, was not provided with any report at this stage. The word we got was that the work is still continuing.
Okay, so just so I have it clear, sorry, Mr. Mothibi, I am struggling a little bit to hear you. You requested it and management said the work is not completed yet, is that right?
That is correct.
So when I take you to the draft report that was sent to the SAA board in December of 2015, I'll take you there now. I would like you to confirm for me whether you've ever seen this before. Well, maybe yesterday when you received it. Let's go in page DD19D, which is the second file, Chair, to page 551.
Maybe, Chair, whilst we are there, just maybe an important reminder to the Chair and the Commission in that the work performed on procurement and contract management. If you call, Chair, Ms. Hofmeyer wanted to know if for the 3 years that had been there, we had not identified the Swiss Port contract. I think it's important to remind the Chair and the Commission that for the first 2 years, that work was in fact not even performed performed by PwC, but it was work performed by our joint auditors. So we would have had performed cross reviews on the work that they had performed, and gotten comfort that the work was in terms of our audit approach, our strategy, and that the results thereof that were appropriate, Chair. So if one has got to be technically correct, it was only in 2016 that one from PwC actually did the full scope review of procurement and contract management.
Mr. Mothibi, I understand that distinction. The Ernst & Young review, though, was done in the year that PwC was conducting the work, correct?
That is correct, yes.
Yes. And notwithstanding what you've said in emphasizing that it was Nkonki responsible for this in 2014 and 2015, I read your supplementary statement to say you don't use that to suggest you aren't, as the joint audit partner, responsible.
And that's important to note. That is
Sorry, there was a negative in my question, so I know it was a bit difficult to ask. Let me ask it with a positive. Do you accept, as the joint audit partner of Nkonki, responsibility for the outcome of the audit opinion, notwithstanding the fact that Nkonki did some of the work and you did other?
I do understand that.
Yes. Okay, let's look at the report that Ernst & Young did provide to SAA. I said you'd find it at DD 19D at page 551. Do you have that?
I've got it now, Chair.
There's a covering letter which is addressed to Mr. N. Linnell. Do you know who that is?
I don't recall that name, I'm sorry, Chair.
Chair, that is Mr. Nick Linnell, and the Commission will in due course be receiving more evidence in relation to Mr. Linnell. There's nothing currently before it, but
I think I've come across the name.
you have actually in some
Yeah.
other evidence,
Yeah.
indeed. Although so far I don't think SAA related, but
Yeah, no, I think it was related to another entity.
Exactly.
Yeah.
So, Mr. Motibe, this is the draft, admittedly, report that went to SAA on the 10th of December 2015, and I asked you to confirm for us whether you saw this at the time.
I did not see it at the time.
And your evidence was you asked management for the outcome of the Ernst & Young report review, but you weren't given anything. Is that right?
That is correct.
It's unfortunate that management saw fit not to give it to you because they did actually consider the Swissport contract. And you will find that at page 597.
What's the page number again?
597, Chair, 597. You see, the facts I detailed to you earlier about the situation with the Swissport contract, Ernst & Young managed to uncover. They came in for 5 months. They vetted procurement and contract management. And what they were able to establish in that 5-month period is reflected on this page. You'll see this is a table. And on the left-hand side, it indicates the section of the report that deals with this contract. The contract is identified as Swissport, and then you'll see key issues identified. Swissport's contract is a month-to-month basis. SAA is failing to realize the cost savings as a result of delays in entering into a contract with Swissport. The delays will result in SAA overpaying for the ground handling services. Then on quantification of loss, they say SAA has failed to realize cost savings of 92,936,578 rand over the period of the 5 years as a result of delays in entering into the contract. And then they have a key that they recommend that there needs to be a contract entered into with Swissport. And then in the key, they identify control weaknesses as the concern flagged. These are the sorts of things that the auditors auditing SAA would be looking at, wouldn't it?
Chair, to the extent that that contract would have been identified for follow-up, these are the items that would have been picked up.
This is exactly, you're looking at what's the cause, control weaknesses, what's the potential loss, correct?
That is correct, Chair.
And then in the second section of that table, you'll see under key issues identified, they say delays entering into a contract. There's no contract in place between SAA and Swissport currently operates on a month-to-month basis. They say here delays in entering into a contract, this is below it. Procurement was concluded in 2013. Chair, just to make a note, the evidence before the Commission is it's 2012. That might just be a typo, reflecting 2013. However, the award has not been made to Swissport. Therefore, SAA is unable to realise the cost savings negotiated with Swissport. And in the key over at the last column, it says this is a matter of concern, which is actually a higher standard as I read this review than just a control weakness. Have you had any time to read the review? Do you accept when I say that matters of concern are more concerning items than control weaknesses?
Chair, I saw this report when it was forwarded to us was yesterday.
Yes.
And in terms of the key that
Yes.
NCR has used, that's how they've identified it.
Thank you. Thank you. So I understand you didn't see this at the time, but do you accept that Ernst & Young was able to identify this contract when it came in to vet procurement and contract management processes, and it had identified these weaknesses in this contract? Do you accept that?
Chair, if I recall, in the scope, Chair, Ernst & Young were required to select 3 quarters of outstanding, 3 selected by management, and I think there were other criteria set. So obviously cannot comment on how they selected the contract, but the outcomes of the review is here in the report, Chair.
Did you just accept it when you asked for a document like this report from Ernst & Young? Did you generally just accept it when management said it was not available to show you?
No, Chair, they didn't say it wasn't available. They said the work is still continuing. Chair, there's a comment that the result goes from management, and we were aware that Ernst & Young were still on site performing the work. So they had not finalized, Chair.
Would it not have been relevant to follow that up with, well, have they made any preliminary reports to you?
Chair, from the inquiries that we made at the stage, it didn't appear that there was anything available for us to look at initially, Chair.
You see, the media had already been reporting about this Ernst & Young review towards the end of 2015. Chair, I see we're close to 5. It may be that I can just complete this point about the media and then we can
That's
adjourn.
fine.
Is that convenient?
Yeah, that's fine.
Okay. So, despite management of SAA not giving you the report, it seems the press got hold of the report. Were you aware of that at the time?
Chair, on the media reports that we had seen on SAA, that report was not identified.
Okay, well, let's see what did make its way to the media. You'll find that in DD19D, that's the second file, at page 423.
423.
Yes, Chair.
Yes.
So your audit procedure that required you to pick up media articles related to SAA did not pick up this article, is that correct?
Chair, not from the...
Just to confirm, this is a Business Day article dated...
Correct.
What?
It's 9 December 2015, Chair. It's sort of the 4th line.
Yes. Yeah.
Thank you, Chair. My question, Mr. Motibe, was your audit procedures that required you to pick up media articles about SAA did not identify this article at the time, did they?
This article is not included in the ones that we had looked at, Chair, or that was identified.
I want to suggest to you that it was quite a key article for your processes to have picked up, because what it records here is, and I'm reading from the first sentence, the Board of South African Airways says it's getting closer to unraveling the reasons for large losses at the airline, with an Ernst & Young forensic report showing that as much as 60% of procurement could be subject to weak business controls. Chair, there's those ampersands in this rendition of the report. I don't understand them to be there in the actual text. It's when it gets printed some years after. So for the purposes of reading, I'm just going to leave those out. So the media seems to have known in December of 2015 that the forensic report was showing as much as 60% of procurement could be subject to weak business controls. Do you see that?
I can see it on the page, Chair.
And it also is quite specific. If you read this article, it certainly appears to me, and you'll correct me if you take a different view, that the writer, Ms. Carol Payton, has seen the report because she talks about what it contains. Did you also form that impression about this article when you read it yesterday, I assume? Or previously? No, this was actually many months ago.
It does appear that the writer has got access to information that we did not have access to.
Yes, yes, because the writer is able to say in the third paragraph, the report shows that 28 of the 48 contracts, which are the contracts that Ernst & Young audited, that is 60%, are improperly negotiated, poorly contracted, or weakly managed. Do you see that?
I read that, Chair.
It would have been useful, would it not, Mr. Motibe, if this had come to your attention at the time that you were asking the SAA board for copies of any reports by Ernst & Young, wouldn't it?
Chair, if it had come to my attention, yes.
What do you think you would have done when the SAA board said it's still in process? Would you have called for it if a member of the media had already seen it?
Chair, if this information was in the public domain, you would have suggested that there is something available to be shared by the SAA management.
How do articles of this importance to what you were doing at SAA get missed in your processes?
Chair, there is a difficult question to answer. We had identified a number of media articles relating to SAA, which have been included. I think Mr. Hoffman referred to it earlier in the meeting, or rather in the session, Chair. So, Chair, there's a big universe of articles out there. We identified those that we had identified and considered what impact they would have had on our audit, Chair.
Ms. Motibe, I should be very clear about the document I took you to earlier. When we went through the working papers that had been made available to the Commission, we were particularly looking for the media articles that the processors had identified over the years. And that set of pages I took you to earlier were the media articles that we could find in the working papers, but they were related to the prior year. When we looked for the media articles that your team conducting the 2016 audit had put together, we didn't find that anywhere in the working papers. Can you enlighten us on that?
Chair, I would have to go look at my file again and bring a response on that.
So it's actually not evidence before this Commission whether this article did or did not form part of those that had been identified by your team, because we actually could not find any articles identified by your team for the 2016 audit. Can you help us today, as a matter of fact, did they review media articles?
Chair, as I indicated earlier in my evidence, that it is not a requirement of the standards, but we do ask and look at media articles that would assist us in doing this assessment, Chair.
You do ask, or you have a procedure that's designed to pull them from the media each month? The
procedure is we ask of our team to pull that out, Chair, but it's not a. It's not that there's not a team member who sits there on a daily basis trawling and pulling every single article, Chair.
Well, maybe by tomorrow, Ms. Motibe, if you have an opportunity, you can just clarify this point for us. whether there were any media articles sourced by your team for the 2016 audit. Chair, I've completed this aspect of the media reporting on the Ernst & Young contract, so I suggest it might be a convenient time to adjourn. And then just to have an indication from you of when you'd like us to start tomorrow.
How much, you did tell me that with tomorrow's witness, you thought maybe have 1.5 hours to 2 hours?
Indeed.
With Mr. Mutibe, how much time do you think you still need with him?
We actually have moved progressively swifter over the course of the day, and
Yeah.
so I think probably no more than 2 hours with Mr. Mothibe, if not less than that.
Yes. Okay, well, in that event, maybe we should, let's start at normal time.
Certainly.
Let's start at 10 o'clock.
Certainly.
Yeah. Okay, we'll adjourn for the day, and tomorrow we will resume at 10 o'clock. We adjourn.
Thank you, Chair.